Yes. Thirteen. You're for the respondent. Who's for the petitioner? Any objection? How much time? 2 weeks. Okay. On a prayer made on behalf of Mr. L. Perme, Learned Standing Counsel, Animal Husbandry and Veterinary, further 3 weeks time is granted for filing counter affidavit. List again after 3 weeks on a date to be fixed by the registry.
Hello, sir.
Yes.
I think to mention item number 16 and 17. On behalf of T-Tapam, we have taken consent from other party.
Yes. Why do you want adjournment?
After 3 weeks,
Why do you want adjournment?
our leading counsel is unable to respond due to medical problems.
How much time?
3 weeks.
Mr. T. Tapak, Learned Counsel for the petitioner, is said to have some personal difficulties to appear before the court today. Stop on a prayer made on his behalf, not objected to by the other side. Matter stands adjourned for 3 weeks. Affidavit filed? Any affidavit filed? Yes. Why? Okay. Your good name? Mr. K. Lawyer, Learned Counsel for the petitioners submits that he needs some more time to prepare the matter. Stop as prayed for. This is the matter again after a week on a date to be fixed by the registry. Yes. Propu. This is 2016 matter. What is the matter regarding? Land dispute. Already almost 10 years now pending. Should have more. Should be taken up. Propu is out of station. Okay, have you informed the other side? Consent is taken.
And for the biggest name.
Any objection? Mr. P. Propu, Learned Counsel for the respondent number 6 is said to be out of station, and an adjournment prayer has been made on his behalf. Stop. The said prayer is not objected to by the other side. So accordingly, let the matter be listed again. After 2 weeks on a date to be fixed by the registry. Stop. It is also provided herein that since the matter pertains to the year 2016, the parties should make an attempt to do the matter on the next court date without seeking adjournment. Yes. Why? Department of DRDA has merged with RD, and they'll be preparing a fresh seniority list. The dispute is regarding seniority.
Yes.
You're for the petitioner.
Yes.
Your good name? Your good name? Idak Bam. Mr. Idak Bam, Learned Counsel for the petitioner, submits that he has instructions to withdraw the writ petition. Stop. Who's appearing for the other side? Anyone? Yes. You are for? Ms. N. Dungan, Learned Counsel for respondent number 1.
Four. That's
Private respondent. Ms. N. Dungan, Learned Counsel appears for respondent number 4. And government?
Standing counsel RD, he's not well for the past few months.
And Mr. S. Tapin, learned additional senior government advocate, correct? Senior government advocate appears for this official respondents and they submit that they have no objection to the claim. Okay. In view of the writ petition stands disposed of as withdrawn. Oh, liberty. You should have said that from before. Then I would have asked you why liberty.
Lordship Liberty, it's 2022 matter. They have taken such a long time to come up to this.
There has to be a reason for liberty. That's
Yes.
why. Why do you want liberty? So then that means there'll be a fresh cause of action.
That's what.
And for that, you don't require liberty. If it's on the same cause of action, then without liberty, you cannot fight. But if it's a fresh cause of action, no liberty is required. Can come anytime. It is also provided herein that if fresh cause of action arises, petitioner will be at liberty to approach this court, as may be permissible in law. Okay. Yes. You are Mr. Barwa. Item 15. Mr. P.K. Gogoi, learned counsel for the petitioner, submits that he has just received a copy of the counter affidavit and prays that he may be granted 4 weeks' time to file a rejoinder affidavit. Stop. Say prayers aloud. You are an outstation lawyer. I give a date after 4 weeks. Good master. In view of above, list this matter again on so and so as prayed for.
21st October.
21st October? Okay. It's not a holiday, I hope. Okay. 21st October.
There you go. No, it's an item number 25. Item number 25. I've got it from the other part. It's item number 24.
On
24 of
24th of October. Why? You want it on 24th? Any auspicious occasion?
council is
You're for the petitioner. What is your good name?
H. Tai. I'm on behalf of A. Sharma.
H.
H. Tai.
Taye. Mr. H. Taye, learned counsel, appearing on behalf of Mr. A. Sharma, submits that since Mr. Sharma has some personal difficulties to conduct the case today, he prays the matter be listed on 24th of October. Stop. Prayer is not objected to by the learned counsel for the opposite party. We have to list this matter on 24th of October, 2020.
Item number 1.
My lord, this writ petition it filed arising out of the non-payment of the compensation.
The western part. He's coming. Sadly. And Charlie? Which number one? 28. Oh, which page you want me to see? 26.
Page 28 is visible, my lord. It is type copy, my lord. So this is notification issued by the Secretary Land Management. So here my village falls under, my lord. Kindly come to district. After district, that is circle, Colorian and Charlie. My circle comes under Charlie, my lord. So location is Ladakh to Charlie. And the name of the project is Frontier Highway. And total length is 1 point something and something like that, my lord.
Your land falls under what? Which circle?
I am from Charlie, my lord.
From
Char-
Charlie.
Charlie,
From Charlie.
yeah, Charlie in Kurungkome district, my lord. So based on this notification, my lord, kindly come to page note 30, my lord.
Yes.
So 8-party notification issued by the Secretary Land Management. The Deputy Commissioner, Kurungkome district, has again issued a notice. It is a common notice, my lord. The notice to the landowners, whose land are going to be acquired by the government for construction of that proposed road, my lord.
Notice
So-
under section 37.
Yes, my lord. So kindly come to page note 31, my lord. This is the names of the landowner, my lord. 31 to 45.
Your name is not there.
My name is not there.
So
My name is not there, and from 31 to 45, their land had been acquired, including my land also, my lord. And they have been already made payment, but my land is yet to carry out survey.
But how do we know that your land?
My land has been, by mistake, my name has not been recorded.
When was this issued?
It is my land.
This notice was issued on which date? There's no date.
Notice issued on. No date is there, my lord. This is issued by the Deputy Commissioner, Kurungkome district, my lord. This is a common notice.
No, that I understand. But tell me the date. When was it issued? How did you get a copy of this?
My lord, from TC office, Kurungkome district, my lord.
When did you get that copy? We don't know this notice.
2nd August 2024, my lord.
Huh?
This list was prepared in the year 2024. 2nd August 2024.
From where you're saying that?
But it is annexure 3 there, my lord.
Hmm?
That is in annexure 3, that is there, my lord.
Annexure 3.
Yes. This is
Annexure 3 is a different one.
Yes,
Literally-
my lord, it is same name is there.
So this,
Now, NHR two is issued by the deputy commissioner. Again, based on that list of landowner issued by the notice issued by the deputy commissioner, and after
see, Annexure 3 is not 2nd September, I mean 2nd August, this 2nd September.
sorry, my lord, 2nd September, it is issued by secretary again, my lord.
No,
It is final notice.
you mean to say Annexure 2 and 3 were issued on the same day?
No, my lord.
Then?
It's annexure.
You just say that this Annexure 2 is issued on 2nd August, now you say 2nd September.
Yes, my lord, it is issued on 2nd 2/9/2024.
Annexure 2.
Annexure 2.
On what basis you are saying that?
My lord, in this list prepared by the deputy commissioner, my name has not been.
Oh, that I understand. Your name is not there. I'm just asking you the date when it was issued.
My lord, it is as per the record, it is 2/9/2024.
From where you're saying that? As per report means what?
This is, my lord, land acquisition notification.
Where is that?
That is para 2 of this annexure 2, my lord. Page 30, my lord.
Para 2.
Yes, my lord.
You may inspect the award from 23/6/2025 to the office. So this is something else. It cannot be August or September.
But the survey,
Mr. Counsel, please appreciate the fact that if you read page 30, the first paragraph or second paragraph, you may like to say that, take notice so and so, okay?
yes, my lord.
Then below that paragraph, you see, you may inspect award from 23/6/25 to 24/6/25. So you mean to say this notice was issued 1 year before,
In 2024, my lord.
2024?
No specific date is there, my lord. But so from my understanding, my knowledge, this notified issued in the year 2024.
Okay, now the main thing is that your name is not there.
My name is not.
What have you done? Have you approached them
So, my lord,
saying that my land is affected? Why are you not including my name?
yes, my lord. So I have submitted a representation also for,
When?
my lord, kindly come to page number 69.
69.
Yes, my lord, this is my representation submitted to the district land revenue settlement officer, my lord, for immediate physical re-verification or spot resurvey of affected land. Honor of Shri Bingyata, my lord.
When did you submit this?
It is submitted on
28th June.
28th June 2025, my lord.
So what is the
So
response?
why this application was filed? The similar situated person has already been made payment, except me. So I came to know that my name is not there. So I have submitted this representation before this authority, madam.
This has not been responded to.
Agent today, it is not been responded, madam. It is pending before the authority.
Yes, who's appearing? Mr.
So-
Ratan?
My specific query that direction will be issued to the deputy commissioner as well as district land revenue officer, madam, to carry out my land survey as well as the verification and prepared a bill and fair compensation may be made to the.
Okay, okay.
Survey is done, awards have been prepared, award notice to inspect the award also has been given. And in fact, his complaint also is that his land has been wrongly shown in some other's name. His land, as per the complaint. His land has been given, the compensation has been prepared in the name of one Pisar Rai, who is the respondent number 5.
Four.
Where is that?
Not four.
The,
Five.
at page 71, if my lord will.
There are two representations.
There are several representations.
It's several.
In the first representation, it did not say that it has been wrongly in the name of Kiparan, Pisaran. But in page 71 representation, the second subsequent representation, it says the complaint in respect of Pisarai, so and so, deliberately and falsely manipulated the compensation bills without any land of his possession and not to release the compensation amount against the aforementioned person. And the serial number also has been mentioned. The land which he is claiming is said to be the compensation has been prepared, award has been prepared in the name of this person.
Isharai.
Isharai. And subsequent representation at page 75 also says the same. Manoj. Then there is a declaration certificate given by the head Gaon Buraj at page 83 saying that the land, the compensation which has been prepared in name of this private respondent, it belongs to the petition.
What is his name?
This
Private respondent in the
Isharai.
the list.
It will be in serial number 374. No, that Sri Isharai.
Next to Nani is my land,
Serial number.
374.
Isharai.
Yes, that also has been in the
What's right there?
Yes.
Yes, in
374.
my name, Tishara is there.
What does it? Why does it say versus? Srimati Benga Nani versus Isharai.
There might have been some objections, some dispute between these two persons. That's why here also it has been written Benga Nani versus Pishara.
Isharai.
Yes,
So there are three persons.
3%.
Benga Nani, Isharai, then the petitioner.
Yes,
Benga Taju.
yes, ma'am.
Bingya Tanik, my father, he got compensation, madam.
Who?
Bingya Tanak, who is my father. He had already got the compensation.
For the same land. or
Before
different land?
me, my father's land is there, and after my father and Srimati Bingya Nani's land is there, again my land, and then Pisarai's land, which is next to the river. What river is there in between Pisarai and my land? One river is there, which is called Purchi. His Pisarai's land is located in the other bank, other part of the river, bank river of that Purchi.
Your land and Isharai's land is not same.
Not connected.
Not same.
In between there is one river is there.
It's separate land.
It's separate land. My land is
Then why did you submit complaint then? Not to
My lord,
Isharai?
in my place, Pisarai's name has been there. Bill has been prepared in his name.
In your place means what?
Yes,
In his land.
my land, in my land.
In
No, Isharai's land is not affected.
Pisarai's land is located in separate.
No, is it affected by the road construction?
Yes, it is also affected.
Then if it's affected, he also should get it.
No, my lord, it is.
You are affected, you also should get it.
Yes, my lord.
But now your lands are all separate. You said separated by river.
It is located in the other part of the river. And my land is also located in the next to Srimati Bingya Nani.
So you have a separate land of your own, isn't it?
Yeah.
It's not overlapping with any other land. So you should be getting your own, you demand your own compensation. Why did you stop? Why did you complain saying that PSRI should not be given?
No, Pisarai has already got compensation, my lord. Against his land also. In between me and Pisarai, my lord,
These are disputes.
yes,
With-
my lord.
there is no any dispute with me.
No, dispute regarding the compensation. You've got compensation already. Why are you getting double compensation?
No,
I have
I'm
not
not-
received compensation. All these things are disputes.
My lord, Pisarai's land is located in the other part of the river. My land is located in the other part of the river, which is just attached to the Srimati Bingya Nani.
No, that I've heard.
Yeah.
That's what you
So, in my place, where Pisarai's name is there, my name should be there, madam.
Today we'll issue notice, tomorrow Pisara will come. He said, no, I have taken my own share. I'm I have not taken money of anybody's share. Then what will happen?
Why not Pisara is also from the other bill?
Court will not be able to proceed further.
My lord, in fact, this writ petition will not be maintainable because under the LARA Act, even if there is a dispute in the apportionment to the compensation, that's section 64, they have to approach the authority. Authority will, the collector will send the disputes to the authority.
64, let's see. Right to bear, right? Compensation, that there, 1030.
It's not the, section 64. 64. Yes, ma'am. Please read. Yes, ma'am. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector to the
Oh,
court.
just a minute. This is like section 18
Yes, ma'am.
of the old act,
Yes, ma'am.
1894.
Yes, ma'am. The for determination of the authority, as the case may be, whether his objection be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the rights of rehabilitation and settlement under so and so, or the apportionment of the compensation among the person interested.
Okay, period is given, limitation.
Yes, madam. Limitation. The provided the collector shall within a period of 30 days from the date of receipt of application may make a reference to the appropriate authority. Provided further that where the collector fails to make such reference within the period of choice specified, the applicant may apply to the authority as the case may be, requesting it to direct the collector to make the reference to it within a period of 30 days. The application shall state the grounds on which the objection to the award is taken. Then, provided that every such application shall be met, a person making it was present on or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. B, in other cases where 6 weeks of the receipt of the notice from the collector under section 21 or within 6 months from the date of the collector's award, whichever period shall first expire.
What is the date of the collector's award in this case?
This, my lord, will see that section 37 is the
No, notice. In the present case, the award has been made, isn't it?
yes, ma'am.
What is the date?
That I will have to take instruction. Otherwise, also, it is if it is referred by the collector to the authority, reference has been made by the collector. There is a word. The word has been given, my lord, will kindly say page 30. In the page 30, the date of award has been page 30.
Where is that?
Take notice that you so and so list given below are
30,
yes
30. Oh,
30.
now,
The first, second, third paragraph, my lord. Take notice that use Sri Srimati list given below are assessed as project affected family, interested party of the land, which is being acquired for the above mentioned project under section 23 and 30 of LARA. And your award has been prepared by number so and so dated 17/4/2025. And on presentation of necessary documents, you shall be paid a sum of list given below. You may inspect the award. Award
17/4/25.
17/4/2025.
So I think there's still time.
Yes, my lord. In fact, his complaint also is within time. Complaint made to the collector. That now the collector has to refer the matter to the authority.
Yes, Mr. Khan.
Yes, my lord.
We will dispose of that by directing the collector to refer it to the authority under the section.
Or
64.
he may approach the collector authority requesting the or for a direction that the collector to send the reference.
No,
As per section 64.
correct. But time factor is there.
Yes.
Time factor is there. Whether he'll be late now to submit a fresh application for reference. The award can be understood to be prepared on 17/4.
17/4. So after 17/4, 6 weeks.
6 weeks or 6 months.
Six months.
You were present before the collector when the award was pronounced.
My lord.
You were present when collector.
No,
pronounced
I
the
was
award?
not there. I was there, but since my name is not there, so I have lodged a complaint, my lord.
You were there.
At the time of land acquisition, I was there, my lord.
No, at the time of pronouncement of the award. I'm referring to, you have this thing act,
Yes.
2013 act.
Yes,
You please come to section 64.
yes, I heard.
Section 64, subsection 2, subsection 2A. The application shall be state the grounds on which objection award is taken, provided every such application shall be made. A, if the person making it was present and represented before the collector at the time when he was made the award, within 6 weeks from the date of collector's award. If you were present when collector made the announcement of the award, you have to file an objection within 6 weeks. In other cases, within 6 weeks of receipt of the notice from the collector. So this notice you will not be getting because your name is not there. Or within 6 months from the date of collector's award. So can you be covered by this, that 6 months period?
Yes.
If it's 6 months, by taking the date of 17/4, 17/9 would be 6 months. Okay. Today is what? Eight.
Eight.
So choice is up to you. We can refer the matter, we can ask the collector to refer the matter as per 64 in terms of your complaint letter dated 36/25. Or you may file fresh application demanding referral to the authority concerned under section 64. But that application will have to be made within 1 week from today. Otherwise, you'll be late. Which one would you prefer?
Because my name is not there, so other similar names are there. They have got compensation where my land has been acquired by the government. So I will file, all right, my lord, I will file a fresh application.
Press representation
Yes.
within 1 week.
Yes, fine.
You have to file within 1 week
Yes, my lord.
because taking into account that period of 6 months.
Yes.
Because 6 months will lapse on 17th of September. If you file after that, your petition will not be entertained.
My lord.
Okay,
Within day or two, I will file.
all right. Art Mr.
N. Tajewala.
N.
Taje.
Taje, learned counsel for the petitioner. And Mr. N. Ratan, learned additional advocate general for the state. Stop having regard to the nature of the grievance projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop. Next paragraph. It is the case of the petitioner that he is in possession of his land situated in Sarli.
Rerung village.
Situated in, where do we get that?
My lord.
Situated in Rerung village.
Rerung, kindly come.
Rerung. Rerung village. Under the Sarli circle in the district of Kurung Kume. So it is the further case of the petitioner that the respondent authority is concerned for construction of Arunachal Frontier Highway from Lada to Sarli had acquired lands, but to the surprise of the petitioner, although his land is affected by the said construction of road, his name has not been included amongst the list of landowners who are to be affected and accordingly compensated for the same. The counsel for the petitioner submits that the Deputy Commissioner, Kurung Kumle District, Koloriang, had issued a notice under section 37, bracket 2 of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013, open bracket, Act of 2013, wherein it was provided that an award has been prepared on 17/4/2025, and the parties concerned have been asked to inspect the award from 23/6/2025 to 24/6/2025 in the office of the ADC Koloria, page 30. Okay. Stop. The learned counsel submits that since the name of the petitioner was not included in the said notice, he submitted a representation for the District Land Revenue Settlement Officer, Kurung Kumle District, Koloriang, for re-verification or spot survey of the affected land of the petitioner on 28/6/2025. Stop. However, the same was not considered and therefore the petitioner submitted a representation to the Deputy Commissioner Colorian on 30/6/2025. Within the petitioner has also taken the stand that the receipt of the compensation has been manipulated by the respondent number 5. Although he has already been compensated, the petitioner therefore made that the amount should not be released to the respondent number 5. A similar representation was also submitted by the petitioner before the District Land Revenue and Settlement Officer, Coloria, on 30/6/2025. However, okay, you've gone to the secretary also. Then you, however, you can sell, okay? And also before the secretary, land management, government of Arunachal Pradesh, on 18/8/2025. Since the representation of the petitioner has not been considered by the respondent authorities concerned, the petition is before the school. Next matter at this stage, Mr. N. Ratan, learned additional advocate general, submits that taking into account the nature of the grievance and complaint submitted by the petitioner would have to approach the reference authority in terms of Section 64 of the Act of 2013. Referring to the said provision, the learned additional advocate general submits that the collector, upon receipt of such reference, would refer it to the authority concerned, which would include objections with regard to the measurement of the land, the amount of compensation assessed, the persons to whom payable, the rights of rehabilitation and resettlement under Chapter Roman 5 and 6, or the apportionment of the compensation amongst person interested. He therefore submits that since a remedy is available under the Act of 2013, the petitioner has to exhaust his remedy available, exhaust the remedy available to him before coming to this court. Next para. Upon considering the submissions made by the learned counsels for the parties, and upon perusal of the materials available on record, including the relevant provisions of provisions of the Act of 2013, it only appears that the petitioner can avail the remedy provided under Section 64 of the Act of 2013, provided that he comes within the period of limitation prescribed. Section 64, bracket 2, bracket small b, provides that grounds taken in the application for objection of the award can be referred to the reference authority by the collector, subject to the same having been filed within 6 months from the date of the collector's award. To stop having regard to the notice issued under section 37 bracket 2 of the Act of 2013, wherein it has been provided that the award was prepared on 17/4/2025, there appears to be time for filing a reference application under section 64 of the Act. Stop. In view of the same, the petitioner is given liberty to approach the collector concerned with an application under section 64 of the Act of 2013, which in any event should be filed within a period of 1 week from today. Stop. Upon receipt of the same, the collector shall proceed with the matter in terms of the further cause of action provided by section 64 of the Act of 2013. Stop. With the above observation and direction, the read petition shall dispense. Public statement.
Item number 3 to 5.
The three read petitions, it's arising out of the same cause of action. Here I'm three to five months.
Yes.
Here
Yes.
I'm putting to challenge the order passed by the estate officer, whereby he has given me direction for vacation, eviction of my property.
Estate office.
Yes. In that area, my lord, that National Highway 13 was constructed. And
Okay. You have not filed, I mean, respondents have not filed counter affidavit.
the estate officer
no
has
affidavit?
filed, has filed.
Estate officer has filed.
Yes, ma'am. For the estate, my lord. And on the last occasion, my lord, there was a direction given to the DSGI also and the government advocate as well. Because since it's a highway, the estate officer doesn't have a jurisdiction because under the National Highways Traffic and Control Act, there has to be a highway administration who will look after these things, unauthorized occupation or removal of any property or obstruction. And in my case, otherwise also I'm saying that I'm not interfering in the highway also. There is no obstruction.
Yes. Mr. Kato, you are supposed to get instructions also in this regard. You are respondent here? Respondent. Or newly pleaded. Respondent number 8. 8 and 9.
Not
And what about
newly
10?
Implemented as such.
8 and 9 you are appearing. 10, anyone appearing as on today?
Then I had served the copy to my brother, Mr. Pada, and he had issued to forward it to NHAI.
My lord, there was a misunderstanding. Yeah, on the last occasion, my lord, with the misunderstanding, because I'm the panel advocate of NSTCIL, not NH, this is NIA.
NHAI.
So it was a misunderstanding. So I've inquired about it, but they said that they are not into this case.
So you'll have to take steps. So far, who has filed the affidavit?
I have filed it.
No, you are the petitioner.
No, I'm no, Your Worship. The state Your Worship.
Oh, you are for the state.
4 and 5 they have filed.
Your position in other places, it's this side. That's why I got confused.
Yeah, I quit that side now. I moved over to this side.
You're for the petitioner or the state?
I'm for the petitioner.
Oh, you're for the petitioner.
Yes, sir.
So then so. So, who all has filed the affidavit?
Worship, 4 and 5.
4 and 5 are the deputy commissioner and the ESC,
Yeah.
the state officer. Now you're saying that this is the national highway thing, so
This national
8, 9 and 10 would have a role.
8 and 9 already served copy. It was served to the DSGI.
Correct. Mr. TSJ is there.
Yeah, January
But 10, what to do with 10?
2023. But otherwise, then also, it's more or less a formal party only, because my actions is I'm agreed by the action of the estate officer, and there is no quarrel about the fact that the stretch of the road where they are seeking to evict me, it is a national highway.
Then
There's
why
no
do you-
dispute on that.
Then why do you make the 10 a party then?
They were not made a party, but on the in fact, on the request of this court only, there was some observation that initially on the first day when this was moved, this petition, the court thought that this state, the Union of India should also be made a party. So they were made a party. But otherwise, initially when this was filed, Union was not made a party. Because the road, the stretch, it is already completed. The construction agency has also left the area. Now the estate officer wants to evict me from my place.
Is there any entry order in your favor?
I say just entry motor is there.
Dated?
Swing motor. Initially, since I was not appearing, I think 20, 30, 30, page number 30. Page number 30.
30.
Yes. No, madam. That
No,
is by
interim
the,
order.
by the impugn.
Not interim order. I'm talking about
Interim.
interim order.
Sorry, yeah.
Any protection to the petitioner?
It is on 25/1/2023.
But where's the interim order?
No coercive action, madam. That was there.
Oh, no coercive measures should be taken. Okay. I see. This is the one. So what is to be done today?
It can be disposed also, my lord, if subject to your lordship's convenience.
How?
Because, my lord, here, only thing I'm saying, there's no dispute that the stretch of the road where the estate officer under the State Act is trying to act it's highway, madam, national highway. And under the national highway, the highway administration has the jurisdiction and the power.
So highways are a party here today.
So highways are a part.
Ministry of Road Transport is there. Then Mr. Kato, what? When will you start? 2 weeks. You file an affidavit also. File an affidavit also. Because let it be on record, whatever stand you take, so that if it goes to the next level, then at least the court understands what is your stand. Apart from the 8 and 9, who else will file? This number 7 is the construction company.
I have affidavit for 7.
7. You're not filing any affidavit.
No, when the issue is whether the
State office.
state officer has the power under the act.
Okay. Parties are represented by the respective counsel, except for respondent number 10. Mr. Isoki. Learned counsel for the petitioner submits that respondent number 10 basically is a formal party. Mr. M. Kato, sorry. Mr. M. Kato, learned DI, submits that since the name of SC, since the name, his name, since DSGI has not been reflected in the cost list, he has missed the case. Stop. He, however, submits that he may be given 2 weeks' time to obtain instructions in the matter. Considering the submission, is this matter again after 2 weeks? Enable learned DSGI obtain instructions. Interim order of master shall come the next date of listing.
All right. All right.
Item number 6.
My please, Lordship.
Yes, item 6.
Yes, madam. Malad, in this matter, Malad, this is regarding Malad, the compensation amount that has to be paid to the petitioner in construction of Malad, this 415, which starts from Itanagar to Bandadeva. And this is regarding the third phase. So the petitioner has a plot of land, Malad, 40,300 square meters, Malad, in the
Yes.
this is a Doimuk circle, man, which is page 20, Malad. Then the government of Arunachal, because this 415 national highway was to be built from Itanagar to Bandadeva, the government of Arunachal Pradesh issued a notification which is page 22, man. Pursuant to the cabinet decision dated 16 March under agenda item number for the governor of Arunachal Pradesh is pleased to notify following specifications of right of way, which widening of existing 2-lane to 4-lane dual carriage way of NH 52A, Malab. This is earlier it was a 52A, Malab. Now it's 415. Its highway name has been changed. Now new 415 from Itanagar to Bandadeva.
So this construction has affected your land.
Yes, Malad,
another to Banda Deba.
what happened here, Malad, the government of Arunachal Pradesh said, Malad, right of way which is existing on those places, the compensation wouldn't be paid, man, which falls under the ROW. So for port, man, serial number 4, this is the would be important. Compensation for land or structure will be provided to the only location where the alignment is changed due to design consideration. Where the design consideration means with the road which doesn't fall within the existing road, man. Those places compensation will be given to the for land and structures. So, Malad, the assessment regarding the assessment, Malad, it was made in 2016, man. It starts from page 24, man.
Your land falls within ROW.
No, it's totally a different alignment. The new road, the new place.
So you're covered by serial number 4.
Yes,
Then compensation of land or structure will be paid, provided only to the only locations where alignment is changed
yes.
due to the design consideration.
So, Malad, what happened in this near this Karsingsa, Malad, the earlier road, the alignment has totally changed now. There's a viaduct has been created, Malad, newly, which is totally, Malad, the alignment has totally been changed. It doesn't go to the fall under earlier road area, totally new area.
So how do we appreciate that?
Now, Malad, the ROW is a right of way in the existing road, man. But here it's a totally alignment has been changed.
No, correct. You show me how by which document can we appreciate the fact that the alignment has been changed?
So that's why the compensation, Malad, the next page, Malad, showing
Yes.
that the government is not denying that fact. They have annexed even the map also. Now the lordship, the compensation starts with page 23, Malad. So my area falls in page 25A, Malad.
23 is a type copy only.
Yes, Malad. The original is not so legible. That's why we have typed.
Uh,
The original is there.
but you said compensation starts from page 23.
The
23 is not compensation.
sorry, 24, man. Starts from 24. This is the original, man. This is not so legible. That's why we have typed. Type copy is 25A, man. My pertains to my area.
Yes.
Lordship may kindly see serial number 1, 2, 3, 4, 5, man. My name is Tar Akak Anthony, man. My name would in 2 places, man. Tar Akak Anthony. In 3rd, it's there. And 5th, it's there. Here we are concerned only with the 5th one, man. 52420, man. Change. 252520. Here, Lordship will see the compensation that has been assessed by the authority, man. This, Your Lordship will find the cocoon, everything, man. That we have given that in our petition also, petition, man, in the chart.
So this is the assessment.
Yes. This assessment, my lord,
Has not been paid to you.
no, man. This is the assessment. Lordship will kindly see, man. The assessment is for all the trees, man. First is cocoon, then hollow, teak, medicinal plant, tree, teak sapling, and hollow sapling. And lastly, jute tree. Yes. So as per this, the compensation, if we total the compensation amount, which they have calculated, is 19 lakhs 60,000.
19,
19
60,
thousand.
60,000.
Yeah, 19 lakhs 60,000.
Okay.
So later on, what happened, my lord, we said, my lord, that when this totally new area it has been passing through, my lord, not only the standing trees, the compensation for the land also should be paid, my lord. That was the grievance of the people who are in that new alignment area. So government
reassess the area.
Hmm.
And Lordship will kindly see through the RTA application, we have collected document, page 26, madam. RTA document which the DC has given.
Yes.
Relevant portions, page 27. So, my lord, will kindly see my name is in the second one, serial number 2. 52420, that same JNH, my lord. Now government has assessed the land compensation. Kindly see, my lord, the Lordship will see, first is the land meter breadth on top, my lord, heading, affected in square meters. My case, my lord, 2 places. Lordship got page 27.
27 years.
Yes. Detail of compensation Kolma area under Doimuk circle for constructing 4-lane viaduct, my lord. This is of NH4 on package C. My serial number 2, my lord, 2 and 3. My lord, may kindly see here about that land, affected land in square meters, man. Top, my lord. Land meter, then breadth meter, and affected land in square meters. Serial number 2, my lord, my land affected is 2196 square meters and 64 square meters. The next quantity that is same, my lord, then rate, my lord. Rate at which the compensation has been assessed. This is 1014 per square meter. So, right side, the total compensation amount which they have assessed, my lord, 22 lakhs 26,744. Not paid, is written.
Hmm.
And for 64 square meters, 64,896. This is the amount compensated, the compensation calculated for the land. Now, my case is, my lord, 2016, they have assessed the area, my lord.
This is an assessment of which year?
This is 2022. 21,
Page 27.
yes, ma'am.
21.
They assess in 2021. The application they have given is of 2022, madam. A reply to the RTA.
Assessment of 2021.
Yes. Now here, Lordship will find this is the assessment for the land, madam. And the 2016 assessment that was made for the standing trees.
25A.
Yes, ma'am.
25A is standing trees.
Yes.
27 is for land.
Yes.
So this both should be added together and paid. to you.
Yes, ma'am.
This is the
That's
okay.
what our grievances. Now we are not against the assessment made for the land. What we are saying is the 2016 you have assessed and land has already been taken over and road has been completed now. Now, for land compensation is all right, but what about the standing trees that were assessed in 2016 or 17? That has not been paid to us. And that's why we are praying this honorable court direction for mandamus to pay the already assessed assessment that was made for standing tree, 19,60,000.
For land you've got already.
Yes,
Land compensation you got.
yes,
Only trees have not.
yes. This is not this is their own calculation. It's not my calculation.
So is there any response? Who has who filed?
Now, the government response is somewhere is a bit contradictory.
This construction of road has been done by whom?
This is of course by
By the state.
no. The tender has been awarded of course by the NH the highway authority.
Highway authority.
Yes.
Who will pay the compensation?
It's a deputy commissioner.
Oh, he will disburse only. Who will give the funds?
Central government.
But central
They
government
have,
is not a
central
party.
government has already disbursed their amount to the state government.
Central government is not a party. Eh?
No, man.
Why didn't you make them a party?
Because land was the compensation was already paid to the state government.
No, that is another thing. Whether paid or not. But they also should know how the money has been spent by the government. Whether the money has been given to the beneficiary or not.
So, in the,
What is this is what widening.
no, this, some, in earlier, Manoj, the road which falls in the earlier alignment, Manoj, it's for widening. Here is a totally new road, Manoj, viaduct area.
What is the exact location?
This Kolma area, Manoj, Doimuk Circle.
Sorry?
Kolma, Doimuk Circle,
Is a
which
new
is
road.
within Bandardeva and Nirjuli.
This is what totally new road.
Yes. Alignment is new.
What is the original work?
Construction of road from Lordship Annexure 1.
It's existing 2-lane to 4-lane
Yes,
from Itanagar to Bandardeva.
yes,
This is the main thing.
yes,
Now, in addition to this, what has happened is there's a new alignment has
Yes.
been made.
in some areas new alignment has been, because
What is that area?
there's a Kolma area.
Kolma area.
Yes. Between Bandardeva and Nirjuli. Now that earlier Lordship, I don't know, if Lordship's aware, that area, Manoj, every year landslide happens, Manoj, and the road are washed away. That's why what they have done, they have built the road in a river bank side, totally new area. So no more landslide would affect that area. Bridge has been built and totally new alignment. It is beautifully constructed now.
This modern road thing was constructed by issuing notification in the year 2016.
Yes.
And apart from that, new alignment. This is Kolma to what you say?
This is Kolma, area is Kolma, between Bandardeva and Nirjuli.
Nirjuli.
Yes.
Who has filed affidavit? This case.
Yes, the government.
What do they say?
They have even given the new alignment also, Manoj, they are not denying this one. What they say is, Manoj, in paragraph 4, what they say is this they have not denied this one. Manoj, what they say is that assessment must in the page 4 of page 4. Manoj. Paragraph, this extension of paragraph 4.
Page 4 of the counter affidavit.
Yes. Once Lordship mentioned, it is pertinent to mention here that since the plot in question of it is caused under Doimuk division under different administrative jurisdiction and thereby the assessment were not prepared in 2016 one. What they want to say is 2016 it was not prepared, whereas the document itself shows it was already assessed and prepared in 2016. Now that has been contradicted in the page 7 manner. Page 7 of Lordship will find. What they in para 4 what they are saying is that it was not assessed in 2016. In page 7, manner, in para extension to that, Lordship and accordingly the board committee assessed the portion of plot of petitioner on 26/10/2021 and found the land area measuring 2,190 square meter accordingly prepared compensation amount rupees 22,26,774 and rupees 64,896 only for left out portion of land measuring 64 square as per ground rate. In place of rupees 9, this is the amount, 19,60,000.
In place of what?
Now what they are saying, in place of 19,60,000,
Lordship will find 19,60,000 that was assessed in 2016, madam. Which I'm sure, Lordship, that standing trees.
So how much was paid instead of 19 lakhs?
Now, that's why, madam, only which was assessed into year 2016, madam. In the para 4, what they are saying, it was not assessed in 2016. Now they are saying 19,60,000 was assessed in 2016. In same breath, they are contradicting themselves, madam.
So according to the board, the committee assessed the portion of Krishna on the 21 and found land valuing 196.
Yes.
This is what you see.
Yes,
And accordingly prepared a compensation amount 22 lakhs. This is what you see.
yes, 22 lakhs and 64,896.
4,000.
Yeah.
These both amounts were paid.
Yes.
And but for left out portion of land measuring for what is this left out portion means?
That was not assessed earlier. That's why this left out 64 square meter also included. For that 64,000.
As was grounded in the place of 19 lakhs.
Yes.
So, so what they are saying is that 2196 square meter has been assessed with 22 lakhs. And for left out area,
64 square.
64 square meters have been assessed.
That's it.
This is,
For
in-
that 64 lakhs.
just a minute, this is in place, this according to them is in place of this
Earlier assessment,
earlier assessment of
19 lakhs.
19 lakhs
60,000.
60,000. 19 lakhs 60,000 assessment was done in which year?
2016.
No, 16.
Now, Lordship.
So this is their stand.
Yes.
So number one, your stand is that some alignment has been, new fresh alignment has been made and for which compensation is payable.
Yes.
First of all, they made assessment for the trees,
Yes.
19 lakhs 60,000. Thereafter, they made assessment for the land
Yes.
and which comes to 22 lakhs plus 64,000.
Yes, ma'am.
Total, they have paid 22 lakhs plus 64.
Yes.
But 19 lakhs 60,000 they have left out.
Yes.
And this being for the
Standing trees, ma'am.
standing trees, you are to be paid.
Yes.
Now in their affidavit, now what they say is that they have paid 22 lakhs 26. And apart from this, for the left out portion, they have calculated this
Yes.
64 square meters. This calculation of 64 square meters is in place of that 19 lakh 60,000
Yes.
calculated for the trees.
Now, no, Manoj, your Lordship will kind of see the annexer which they have calculated. Lordship will find the 2016 assessments only for trees only, man. And 2021 Lordship will see is only for land, not for standing trees. Totally different. And Lordship, they have even given the rate of the land, man. Now, how they can say it's in lieu of that standing trees, man? They cannot, man. In 2016 assessment, the rate at which the compensation has been assessed of standing trees is particulars have been given, man. For cocoon, what's the rate? For teak, what's the rate, man? For jutli, what's the rate? Everything has been given, man, in the chart. And
Did you file a rejoinder?
yes. Yes.
What did you say?
Now, what we say, but already the plan was taken 2016, man. Assessed everything, man. Now,
What a very long paragraph. What is this?
that's why
Paragraph
four,
4 goes on and on, on and on.
yes, madam. Paragraph 4, it's from page 4 to 11 now. Now, but in the affidavit also,
What did you say in your rejoinder?
What we have said, madam.
Yourself, you have
Yes.
filed rejoinder, you say?
Yes. Paragraph 4 that we have replied, madam.
Which is the relevant portion?
Paragraph 4. ma'am. The-
Your
Par-
paragraph was also quite lengthy. Which
But
one?
that your lordship will see the paragraph for which they have replied. It runs from page 4 to 11, madam. That's why we had to, madam.
No, so what is your reply to this particular?
What we have just did, what's for standing trees already assessed in 2016, madam. Those, madam, plantations, what they say, plantations and all the, then,
Okay, one thing,
Yes.
the land assessment was done in 2021,
yes,
plantation in 2016.
yes.
So in 21 of that plantation will not be there.
That's why we have said in this.
That's what you're saying.
Yes.
Now, who has certified that 2016 assessment?
Madam, it's a board of constituting 7 members. Down below, madam.
Where's that beginning? Where?
Signatures are there, lordship. In the
Where?
assessment.
The assessment.
Even the lordship, page start from 24, man. Right side, lordship will see it's, members of 7 member signature, right side is a deputy commissioner's signature. It's a seal and signature. They have not given the date, madam. Page 24.
This is an extra to the notification at page 23.
Yes. Lordship will sign below of the document, but the seal of deputy commissioner is there. But
No, that is there, no doubt. I'm asking you about this document. Where does it come from?
Yes, this one, according to the notification,
Is there any forwarding?
no, madam.
What is notification?
This we have obtained through RTI only, madam.
What is page 22 and 23 then?
This is moment notification, but actually what happens in other cases, land is acquired, madam. Here, because this, most of the places, the land falls in existing road, madam. What the government has said, the compensation would be paid only for where there's a deviation in design. Madam.
Okay, now this page 27.
Yes.
The amount assessed and paid to you.
Yes.
22 lakhs and for 64,000.
Yes.
Why is it written not paid, not paid?
Madam?
It is written not paid.
No, at the time when we RTI application, at the time it was not paid.
When was it paid then?
Then
Subsequently.
it was paid on February, 23rd February of 2023.
On which date?
23rd February 2021, 23.
23rd February 2023.
Yes. Because this RTA was of 2022, madam. At that time, it was not paid. The government has annexed it.
Okay. Now, why was the payment not paid immediately? Why was it paid later on?
We raised some objection.
Because what we said,
Assessment was of the year 2021.
Yes.
for land, earlier, madam, it was,
Payment came only in 2023.
yes.
Second only in project. review. Because in that list, lots of can see that others have been paid already.
Others have been paid.
Maybe because he has some objection, that's why maybe he declined to let it at that point of time.
Okay, now, what do you say about that 2016 assessment regarding trees?
Because this is not. Ask. Standing are not there. This one he has not
Standing,
paid.
standing trees are not there. Which year? Which year? In which year? See, in 2016, when all these persons went for verification, they found the trees. So many things are written here, and number of signatures are given here. Now, Tar Akat Anthony is the petitioner.
Yes.
Leaving the petitioner aside, what about this Debia Nia, then Takam Xavier?
They have all already paid.
When? Find out when they were paid. If they were paid, why are you left out?
Some of the persons, they have not taken because they have also filed it before the High Court.
Why?
So some of the petition, some of the.
Why they have filed a petition? They're not
So total in
they're not accepting the assessment.
It's not this,
I'm not talking about the land assessment. I'm talking about the tree assessment in 2016.
Yes.
This list
Yes.
comprises of not only the petitioner, there are three other names.
Yes.
What has happened to these persons? Were they paid? If yes, why not the petitioner? You have to distinguish. Because your affidavit simply says that apart from that, what you call 196 square meter, we have added 64 also. This 64 is in lieu of the 2016 assessment.
No. It's just some,
No, this is what they're saying.
no.
It's there.
Not it, but.
Huh?
No, in the, they have made it clear, it was left, it was not calculated earlier, that's why.
It's left.
Left out.
Then what about the 2016 calculation?
Now what they are saying,
That is purely for the trees.
yes, now what they're in the affidavit, what they're saying is, this 22 lakhs and 68,000 for 64 square meters. These, if you calculate, both of them supersede the 2016 assessment. That's what the reply of the deputy commissioner.
This has not been denied. So it's structure and so I have said it again. But therefore, what it says is that however they captured by the board in 2006, but the projection subject is not around the set is not for the
Where is that? What?
it's not there.
No, from where you,
He's saying,
no, from where you reading that?
he
That
can
is your instruction.
yes,
That means you are controverting your assessment.
no, the land assessment is 2021.
No, I understand. See,
Yes.
no, what I'm saying is that
This is,
in 2016,
yes, no,
certain group of officers,
yes,
including the deputy commissioner, have made the
Yes.
verification, and they found that these trees are there,
Yes.
and this is the assessment.
Yes.
One assessment chart is prepared. After many years, the same authority, maybe different person, same authority says, no, there is no such kind of vegetation. I have checked the drone footage and all that.
that's what. Yes,
Can you say that at this stage? Let him what?
press representation.
No. Pressure representations has already been rejected,
Anyway, you think about it. I'll come back in 5 minutes.
Yeah.
Okay.
The concluding matter, that the government affidavit lordship will kindly see the assessment, the verification report, government affidavit, which is page 15.
Page 15.
Yes. It starts from page 14, Annex 3.
Yes.
Forwarding of joint inspection report. This is, now lordship will find,
Forwarding.
Yes.
Okay,
Joint
that's page
inspe-
14, that's page 14.
Yes, ma'am. Now, the joint verification is page 14.
This is the year 2021.
Yes, sir. That's why, but I just want to, uh, in the verification, what they did, sir. Page 15,
Hmm.
In compliance to order number such and such dated 24 August 2021, a joint verification has been carried on proposed site on 25th August 2021 at 800 hours for proposed construction 4-lane highway viaduct under NH4 on 50 Dekasi, New Julie, Kolmal. This is the area. In the presence of all the affected, following such and such, the next, 5 members were there. Following our findings and observation after physical survey of the site, the proposed plot for construction of 4-lane highway viaduct falls under the administrative jurisdiction to circle under Papumpara district. The additional 10 numbers of lane owners has been identified along with proposed stretch of viaduct area in addition to 7 numbers affected already enlisted for compensation. These 7 are already, it was it's case like mine, was already enlisted. In compensation as such, total of 70 numbers affected lane owners identified along the proposed construction corridor viaduct area. Further, this may kindly noted. Further, the additional strengthening structures and assets like horticulture, agriculture, forest items, which are not been considered included in the earlier compensation assessment. Those all the forest agriculture items has not been included, which was already assessed earlier. Although land owners welcome, this is not relevant, have been measured with along with the coordinate. Now, Lordship will kindly see page 16, This is the area. Lordship will see plot my lane was second one, from left. Total area for Tara Antony.
Now, what is the purpose of this joint verification?
Now what here it says, only for land decomposition because it is new area, only in this joint inspection report, what it says is only for land, It's not for the verification of which was already assessed earlier, like horticulture and forest standing trees.
Come back to page 14.
Yes, ma'am.
This is by the in charge district land revenue and survey officer, is it?
Yes, ma'am. He has forwarded the joint verification inspection
Okay,
survey
okay.
report.
So what was the term of reference? It says in compliance of order dated 24th August 21. What is that, 24th August?
It is page 13,
13. It has been brought to the notice that I'm saying. No? Okay. The assessment of the following land owners has not been assessed.
Yes, in the previous assessment for construction of viaduct area, New Julie Kolma. This 8 numbers, my lord.
Are you there? No.
No, because mine was already assessed earlier, man.
Okay.
That's why the joint inspection report says that, man. That's why I'm reading that one, my lord. 2, where are 2?
The additional 10 numbers of land.
Yes, owners has been identified.
But the names are only 8 of them. Why, from where 10 has come now?
My lord, in inspection, 2 more might have come, my lord.
But it should be indicated in the verification.
Yeah, yes.
That in addition to the 8 record persons, there are 2 more lands. Where is that?
That has not been done. In addition to 7, my lord, numbers affected already enlisted for compensation. I come under that.
How do we know that?
Because
7.
yes,
How do you know 7 includes you?
well, that's why in a map I have shown, man.
You also.
My lord, these are the, Lordship will kindly see the page 16, man.
Just a minute. Mean?
Yes.
What does it mean? The following are the findings and observations after physical survey of the site.
Yes.
Okay. Now, number 3 says further additional standing structures and assets like so and so,
Yes, ma'am.
which are not being considered included in
The
the
earlier compensation. Like standing trees, horticulture, agriculture, because they already was assessed in my case.
So things are not complete. What does it mean? The following are the findings and observations.
That's why
So they have made some assessment over.
this is the assessment of the land compensation
Where is the assessment?
that I have shown in the repetition, Lordship. That
Dated?
Bharat make a kindness page
27.
27, Lordship.
27 is the assessment.
Yes, repetition.
But this includes you.
Yes,
But the reference given here is at page 13 of the counter affidavit. Does not include your name.
no, Bharat,
How do you connect these two documents?
no, page 27, Bharat.
Correct. 27 includes your name and
Yes.
serial number 2 and 3.
Yes,
So where was it included in your name is not included in the order at page 13 of the counter affidavit.
that's why, Bharat. I'll read, Bharat. It has been brought to notice understand that assessment of the following land affected owner has not been assessed in previous assessment for the construction of viaduct at Nirjuli, Bharat. These are people whose land has not been assessed earlier, Bharat. Because my case, Bharat, it was assessed earlier, Bharat. 2016, Bharat, I've shown that, but assessment.
No, you are saying that this order
Yes.
at page 13
Yes.
was a direction to make the survey,
Yes.
inspection and all
Yes.
that. And after they did the inspection, they've made the assessment.
Yes.
Where's that assessment? Page 27.
Yes. This is the assessment. Page 27.
How many names are there?
Here, Bharat,
There are so many names,
yes. 17, Bharat.
17 names. So the report does not say 17 names, whether it says 17.
Yes,
Okay.
the 10 plus 7, Bharat.
17 names.
In joint verification report, 10 plus 7.
The additional, is 19. Is 19. What is the name of the petitioner?
Serial number 2, man.
2196.
Yes.
16. Thousand seat 27.
Correct. 2196 only. It doesn't take care of that 64 square meters.
Yes, man. That's why it was included.
64 square meters came later on.
Yes.
15. I'm looking at page 15 of the counter affidavit.
Madam.
What does serial number 3 mean?
Madam, that's why my understanding, madam, those madam, horticulture, agriculture, forest items which are not being considered included in the earlier compensation.
So,
Therefore, madam,
something wrong with the language.
language, madam,
So does it mean to say that the compensation for horticultural, agriculture, forest items
items, madam.
have not been included?
Yes,
This is what it wants to say.
now logical, this will make it clear, madam, page 18, madam. Government's own document, madam. It's only for land, madam.
That's how we can see.
This
From-
in my case, madam.
No. See, that we can already see
Yes.
from page 27 of your writ petition.
Yes.
Nowhere in this chart do we see any such kind of standing trees, crops and all that. Nothing is there. This is basically for land only,
Yes,
isn't it?
yes,
So the document itself goes to show that this assessment is not for trees, crops,
yes.
etc.
Yeah.
It's only for the land.
Yes. What we are saying, we are agreeable to this assessment, we have already taken the amount, madam.
And you have taken also.
Yes, what we are saying is the 19 lakh 60,000.
You're taking us back to 2016, whether 19 lakh 60,000 has been assessed for your trees
Yes,
in your land.
yes. Now, after in 2001, madam, they have assessed with drone footage, madam, how they will assess the trees now, madam.
Drone
Sure,
footage is of which year?
2021, madam.
Where is that drone footage mentioned?
Madam, 7, madam. Page 15, madam.
Page 15, 7, what 7?
Madam, I'm sorry, 5, serial 5, down below. 5, the respective individual and land owners, it's a plot of land area have been measured with geo-coordinate map along with drone survey. 2021, this is the joint with.
Drone survey map of which year?
This is 2021, of course, madam. That's how they measured.
No, the verification and all that came in 2021.
Yes.
But it may also mean that the survey was relied upon was of drone survey map of earlier years. We don't know.
16, madam. It's all physical verification, but all the members, they have put signature for 7 members.
So today we are concerned with that 2016. only.
Yes, ma'am. Because here the trees have not been assessed, only land has been assessed. What we are praying is that the assessment of the trees which have already been done in 2016 should be done.
How did you get this document, Annexure 3?
Annexure 3, ma'am.
Your Annexure 3?
Yes,
Writ
through
petition.
RTI, ma'am.
When did you get it?
Madam, the 21, madam.
Your RTI application.
Here, madam, we have not annexed, madam, other. Next, madam.
But you must have mentioned it, just any statement to that effect. What is this annex? Annex 3?
Yes.
Say,
Not denied, madam, yes. Responded on. Not denied.
what they have said that during the latest assessment in 2021, they have not found any standing trees.
Yes,
That's all.
that's all.
Paragraph 7.
Yes.
After 5 years, how will you find all this?
No, that's why we have said, madam, it's absolutely, madam,
And construction also has taken place, isn't it? Highway development, construction, all that. So the trees, naturally, the trees will be cut down and all that.
in a writ petition also, we have annexed the photographs, madam. In the photographs also, what you can find the trees, madam,
Photograph taken when?
while the construction was going on.
Where is that?
Your lordship, can you see page 33, start. Now they have madam, almost destroyed all the standing trees. Start from page 33. They have cut down madam, most of the trees.
This is pictures are of construction
Yes.
being in the process.
Yes.
It is not that before construction.
No.
So that there is not much of vegetation.
Lordship can find, madam, even during the construction, trees were there. Some of the trees.
Some trees are there, but we
Obviously.
don't know. We don't know how many trees were there on this much trees, that much
Yes.
trees, you say.
That's why madam, those were what we are trying to show is, madam, some of the trees were
See,
standing, madam.
we'll do one thing. We'll adjourn this matter. And not simply adjourn the matter. I'll ask the government to get instructions with regard to what has happened to Tel Tallinn, Debia, Nia, Takam, Xavier, all these people. How have you paid them? And you will produce the records also regarding this assessment of 2016.
Not-
Can you get it by next week? This is item number.
Six, madam,
Uh,
next week, I think Justice Tata would be there, madam. He would be able to take up this matter. Oh, my lordship is. Sorry.
Part Mr. P. Tappo, learned counsel for the petitioner. Submits that the respondent authorities concerned have constructed public widened the existing 2-lane road to 4-lane road from Itanagar to Bandadeva in the year 2016. Stop. In the said process, there were certain variation in the alignment of the road construction between Bandadeva and Nirjuri. Stop. An assessment was made pursuant to the notification issued by the Secretary Land Management, Government of Arunachal Pradesh, white notification dated 29/3/2016. So he submits that an assessment for damage towards trees, crops, etc. was done in the year 2016, and for which the damages caused to the petitioner was assessed at rupees 19,60,000. This is 19,60,000. So further, compensation assessment for the affected land was also made in the year 2021. Wherein it was shown that the petitioner's land measuring 2196 square meter and also 64 square meters were affected. And he was accordingly paid a sum of rupees 22,26,744 and 60 rupees 64,896 respectively. So the Learned Council submits that although compensation for the land was given to the petitioner on 23/2/2023, but the assessment, but the compensation for damages caused to the trees standing in his land assessed at rupees 19,60,000 in the year 2016 has not been paid. Stop. Aggrieved is before this court. Next para. The respondent number 4 has filed an affidavit of possession wherein it has been stated, paragraph number 4, that instead of payment of rupees 919,60,000 towards the damages caused to the trees, the land of the petitioner, comma, sum is 64,896 has been paid to the petitioner. for the left out portion of land measuring 64 square meters. Stop. The same is in place of the assessment made towards the standing trees. So, the assessment made in 2000 indicates that the assessment of rupees 64,896 is towards the standing trees in the land of the petitioner. Stop. The assessment made in the year 2016 not only shows the assessment towards the damages caused to the trees of the petitioner, but also 3 other individuals at page 25, capital A of the petition. Madam, your good name? Miss G. You are the senior government advocate.
Additional.
Ms. G. Learned, additional senior government advocate, on being asked as to whether the 3 individuals who appear in the assessment of damages to trees made in the year 2016 alongside the petitioner has been paid the compensation or not. Submits that she will have to obtain instructions in this regard. So, additional senior government advocate shall obtain instructions with regard to payment of compensation for damages caused to trees as indicated in the state assessment of the year 2016, and also produce the relevant reports by the next day. This is the matter again on so and so. Can you get
16 month,
Tuesday?
Tuesday.
What is the practice here? Tuesdays and Thursdays supposed to be a division bench day?
Yes.
We'll have it on Wednesday then. 17?
17.
17. This is the matter on 17.
Item number 7 and 8.
You want some more time?
Yes, sir.
How much time do you need?
After it is.
No, madam. In last occasion also, they have not 2 weeks time. What is the matter regarding? What is the issue involved?
It's the,
Service matter.
yes, madam.
You're having interim prayer also. I mean, interim order in your favor. Two weeks. Okay. That's paid for by Mr.
H time. H time.
H. Tying.
Yes.
Done it.
On behalf of Standing Council, Tabatagan,
Any council
for Education Department, Tabatagan.
appearing on behalf of Mr. So and so, Learned Standing Council, Education Department. Further 2 weeks time is granted for filing, to obtain instructions and for filing counter affidavit. Fix on a date. Sorry? Interim order is there, but I don't think there's a limit to that. There's no, we will continue. Yes.
Item number 9.
Meetings complete.
So, let it be heard.
For hearing.
Hmm?
Matter will fix for hearing.
What do you say? Will issue rule then, or what? What is the issue regarding?
Regarding matter implementation of consumer model rule 2021 for payment
Implementation of,
consumer model rule 2020.
okay. Why it's not implemented?
It's under. I have received instruction, madam, that it's under process, madam.
No, if you make the rules, is there any such kind of provision which says that it will be implemented?
Oh, madam, but this rule is central rule, madam. So state government is doing it, madam, under process.
Meetings are completed, but- It's-
Item number 10 and 11.
Allowed.
No, you've got the relief. Both the rate petitions.
But then,
What is your good name?
and only.
Miss N. Hondi, learned counsel for the petitioners, submits that she has instructions to withdraw the recommendations. Mr.
Why did I?
Y. D. Ram, learned government advocate,
Yes.
submits that he has no objection to the prayer. Therefore, both the recommendations are disposed of as withdrawn.
Item number 12.
Here, your lordship, on behalf of respondent number 3, we have filed, your lordship. We need some more time to file on behalf of respondent number 2, your lordship.
How much time?
So 3 weeks, your lordship.
3.
Yes, your lordship.
Yes, Mr. Counsel. So Y. D. Ram, learned counsel, learned government advocate, submits that although affidavit of possession has been filed on behalf of respondent number 2,
3 years.
respondent number 3, he may be given 3 weeks time for filing counter affidavit on behalf of respondent number, since he is yet to receive instructions. Further 3 weeks time is granted, filing counter affidavit of respondent number 2. Your good name?
Keep eyeing. Eddie,
Yes.
Eddie Pine.
Yes, E. Payang, learned counsel, Mr. E. Payang, learned counsel, appears for the petitioners.
Item number 14.
Your lordship, we have not been served with the extra copies till date, your lordship. This was listed on in the month of June, your lordship.
Why don't you give the extra copies? How many copies you require?
Your lordship. Very
Although notice was issued on 9/6/2025, Mr. Y. D. Ram, learned government advocate submits that he has not been furnished with extra copies of the writ petition. So petitioner to serve, how many copies would you require?
to your lordship.
Serve 2 copies of the writ petition to Mr. Y. D. Ram within 2 days. Stop the respondents are given 3 weeks time to file their response. List again after 3 weeks.
Madam.
Item number 18.
For fixing the matter for hearing, the pleadings are completed. Hearing to say,
After here, then, right?
my lord.
He was here.
Yes, here. No.
So when do we fix it?
My lord, next week, my
Next week. What is the matter?
matter is, my lord, pertaining to reversion from the executive engineer to my lord, assistant engineer. It's a basically it's a my lord promotion and direct between. It's a tussle between. So landed my lord in another my lord the division bench which is pending. The largest single judge held my lord that the promoters they have exceeded the quota. So based on that, my lord, we are reverted. And against the reversion, my lord, they have challenged in this. And they have obtained the my lord interim order without challenging the largest single bench before the division bench. Although after that, my lord, they have filed the appeal for the division bench. My lord, even my lord, condemnation delay is not yet, my lord, that was allowed. Next week, when I need that can happen.
You want a particular date or we'll just say next week?
Monday, my
The parties are represented by the respective councils. Meetings are complete and the matter may be listed for admission hearing on 15th September. Let's wait for this now.
Item number 19.
The lordship, we have taken steps upon respondent number 2 and 3.
Well.
Uh,
You took steps on respondent number 2.
2 and 3.
When?
We have already filed affidavit regarding this lordship.
Affidavit means,
Affidavit of justice service.
but that is not available in the record.
I am representing one.
1 and 3. What about 2?
We
Have you checked the file? You should check the file of the file. Out here, there's an office note, says it's dated 6/9.
lordship, I have the PDF of the
Says
Justice
steps to service of notice upon respondent number 2 by Dusty Moat have not yet been taken.
yes lordship. I had regarding this. I had spoken to the registry. They told me that they have furnished the copy here. Let's see. Because the affidavit was regarding service to both 2 and 3.
Oh, I see. Have they received?
Yes, lordship.
1 and 3, council is here. What about 2? 2 has received or not? Who is number 2?
This national highways and managing that. New Delhi.
How you serve that by Dusty?
That's the yes, Lordship. And in lieu of that, we have filed affidavit. The service was done on 27 June 25.
See, the kind of notice that you give, you should indicate the respondent number also. Isn't it? You say, sir, please take notice that the above noted petitioner has been filed. Petition has been filed before the High Court by the above named petitioner. A copy of the same is forwarded to you for ready reference. From so and so petitioner to the managing director and HIDCL. And you should write respondent number 2,
Yes, Lord.
like that.
Yes, Lord.
It was served on 27/6.
Yes, Lord.
Both. No, 36. Your good name, please.
E-Pine. Eddie Pine.
This is item number.
19.
Mr. E. Paying, learned counsel for the petitioner, submits that he has served notice by way of Dusty upon respondent numbers 1, 2, and 3.
2 and 3 only.
Respondent numbers 2 and 3, as permitted by this court, and he has filed an affidavit. That's proof of service. Stop. Upon perusal of the said affidavit, it is seen that the notice was served. The respondent number 2 and 3 on 27/6/2025 and 30/6/2025 respectively. Now, accordingly, notice is accepted to be complete. Stop next. But at this stage, Mr. K. Lawyer, learned counsel. You are the K. Lawyer, learned CGC, submits that you will be representing respondent numbers 1 and 3. Stop. He prays for how much time? You'll be praying for counter affidavit?
I've already filed.
Already filed. And submits that he has already filed the counter affidavit of the respondents he represents. Stop. Since respondent number 2 is not represented today, let the matter be listed again after 2 weeks on a date to be fixed by the registry. I think we can finish it up, isn't it? These are motor matters. There's no hearing matter, right?
Yeah,
It's item number 13, we upgraded at 2 p.m. method.
Item number?
Item number 13.
Oh, 30 is for hearing.
Hearing method. This method will be upgraded method. Several location method due to shortage of time that could not heard.
What is the matter?
Is regarding termination of the petitioner's service.
So today is your lucky day. Today is your lucky day. We don't require to upgrade it. See, the item 30 is the only hearing matter left. The other item 20 to 24, 25, 26, 27 These order matters, short orders will be passed. Then we can hear who's on the other side.
PSGI.
Okay.
He also instructed me to update them.
No, we'll not update it. Okay. We'll finish the orders. Then we'll take up your matter. Yours will be the last and only hearing matter. There's no other hearing matter.
Yes, ma'am.
We'll assemble at 2 again.
Item number 20.
Yes, for the petitioner when the matter is called. Although Mr. Y. Ram Nanak, Governor will consider it. So this matter has been listed. Since fresh steps was not taken by the petitioners for service of notice upon respondent numbers 3, 4, 5, 10, 11, 12, 13, and 14. Stop considering the same. Further 1 week time is granted. Yes, to take steps upon the steps for service of notice upon the opposite respondents. This is the matter again after 3 weeks on a day.
Item number 21.
I will be allowed to withdraw the matter.
No.
Yes.
Item number 22.
May I please submit.
Yes.
My lord, this contempt petition has been filed due to the non-compliance of the order, judgment and order dated 10/2/2025 by the state respondents as well as the NHPC. Thereafter, after the filing of this contempt petition, the state respondents via 2 interlocutory applications sought for time extension, which has been granted. For your ready reference, my lord, I would like to place these orders of the IA.
No, just a minute. Before that, why has it been listed today? This matter.
My lord, the state respondent is supposed to comply of the last order in IA 149 of 2020.
No, before that, see, have you seen the office note? 6925.
Yes, my lord.
What is written there?
The steps not done to respond.
So why didn't you
2, 4.
take steps?
Steps on 1, 2, 4, and 5. My lord, I'll take the steps within these 2 days.
Steps. Then only we'll consider. As paid for by the learned counsel for the petitioner. Further 3 days time is granted to take steps for service of notice upon respondent numbers 1, 2, 4, and 5. This is the matter again after 3 weeks.
My lord, can it be posted on 17th, my lord? Because my lord, already lots of time have been granted in the meantime.
2 weeks on a date to be fixed by the registry.
And can it be on 17 a fixed date, my lord?
No, I'll not give it. 2 weeks. Take steps first. Which legal, unless they know that. So,
Item number 23.
Oblige.
Yes, sure. The applicant appearing in person.
yes, what is this application?
Your Honor, it is a treatment application under order 1/10. Your Honor, my only ground in this application is only two, that the first, Your Honor, that I have met the representative. All the impugned orders was initiated on the basis of my representation, including, Your Honor,
No, you tell me, what is this IA for? You are the writ petitioner also?
no, Your Honor, I am not.
Then?
The petitioner respondent has appealed against the impugned order of the deputy commissioner, where in the questions of government land, occupied, illegal occupied over the public premises.
Okay, so why are you appearing in person?
Your Honor, the point is that the entire impugned order was initiated on the basis of my representation. I am from the Lohit district, and the land in question is allocated to the Kendriya Vidyalaya, located in the Lohit district. Your Honor.
Okay, who is appearing for the other side? Objection filed.
Yes,
Yes, Your Lordship, we have filed our objection.
When? It's not reflected in the order sheet.
responding petitioner has filed the
When?
third.
See, problem is
Third
that
hearing
no,
over-
no one is looking at the office note in making submission. Straight away, you are bringing your own brief and submitting.
I have received the
At
copy,
least
but there is
go
no-
through their court records also. What is written here, you must see. See, there's an office note saying 6/9/2025. Affidavit in opposition not yet filed. And you say you have filed. When did you file?
Your Lordship, I'm not aware of the date, but we have filed.
I have received the copy as well.
Advance copy maybe, but they have to file. Registry will say, write this kind of note without after receiving the affidavit in opposition. I don't think so. Do you have any filing number, serial number like that to show that you have filed?
So we don't have that.
Then there should be an acknowledgement saying that this is the serial number I filed on so and so date. Then we'll ask the registry to verify. But once they have written here that there is no affidavit, what more can we say?
You know, I have filed this application on 7th of March 2025.
Oh, that's okay.
And the respondent number 1, 2, 3, 1 and 3 has also not objected this application. Your Honor.
This is for impletement.
Yes, Your Honor. It's a
Do
response.
you have objection to the impletement?
Yes, Your Lordship.
Then where is your objection? You're for the petitioner, is it?
Yes, Your Lordship. Your Lordship, though we have filed our objection.
The counsel for the applicant, no, counsel for the respondent / writ petitioner submits that she has filed objection to the IA to stop. However, the office note dated 6/9/2025 indicates that objection / counter affidavit has not been filed by the sole respondent. But has not been filed till date. Is there any other file apart from this in the IA? Counsel for the applicant, counsel for the respondent to take up the matter with the registry. If objection has not been filed, the same be filed within a period of 1 week. This matter again. After 2 weeks, on a date to be fixed by the registry.
Item number 24.
Maybe grants some further time to file our application.
What about your for which respondent?
Respondent number 1 and 2, Your Lordship.
3, 4, and 5?
Lordship, for that we have taken step, Lordship. They are private school.
Mr. Y. D. Ram, learned government advocate, appearing for respondent number 1 and 2, prays for how much time?
3 weeks.
For the 3 weeks time to file counter affidavit. Prayers allowed.
Lordship, it may be continued. Lordship.
Office note dated 6/9/2025 indicates that neither ID card nor unsub notice has returned back from respondent numbers 3, 4, and 5. Office to track the postal consignment and put up a note by the next date. This is the matter again after 3 weeks on a date to be fixed by the registry. What is the interim prayer? Interim order?
Lordship, this stay of this Gabang Saman.
Interim order passed earlier shall continue till the next date of listing.
ABI.
Item number 26.
Point 3. Not sir. Who is appearing for 1? None appears for the petitioner when the matter is called. Mr. Your name? K. Lawyer, learned CGC appears for respondent number 1 and submits that respondent number 1 is not a necessary party. Stop. The said submission will be considered at the appropriate time. Stop. Office note dated 6/9/2025 indicates that service report from respondent numbers 2 and 3 are still awaited. This is the matter again after 2 weeks. Provide service report from respondent numbers 2.
Item number 27.
Similar order. Okay.
Item number 30.
Yes.
Petition, actually the review order in order is on page 31.
Service matter.
Serviceman. I was regimental number 1. My ITBP, I was working under ITBP.
ITBP. Page 31.
Page 31.
31 you have challenged.
Yes, my lord.
What is that?
My recommendation. Regimental number 04023063. Constable GD Omkarnath Pandey at company posted at 10 Battalion ITBP force appeared before Sri Nishit Chandra, Commandant ITBP for preliminary hearing proceeding on 29/9/2016 in connection with disciplinary proceeding for remaining absent from active duty in camp premises of internal security duty company Itanagar 31st Battalion ITBP and having accused of the following charges. The hearing record of evidence is directed to be made as per 10th Battalion Order number 1532-310-16 for as per Rule 50 of the Third Order Police Rule 1994. There were 3 charges. One charges is 21A. Kindly see the 21A of the ITBP Act.
Just a minute. What is this order regarding?
Removal. And the punishment was about what?
No, this particular order. This is memo of charge over.
No, my lord. This is the final order.
This is final removal order.
Yes, my lord. Sentence is on page 35.
Under what provision?
My lord. As per one of the ITBP.
51.
51C.
51C. Someone give me the ITBP.
ITBP Act 99.
Rule 50. section of rule,
Rule. Sorry, madam, this is section.
section 51,
C of ITBP.
capital C
Section 51C.
of ITBP,
ITBP Act 1992.
1992.
For remaining absent from duty on, my lordship, on 29/9/2016.
How many dates?
Only one day. He was not, he was absent from duty when the, on a particular time, my lordship, 1800 hours, at 1800 hours, charge 2, my lordship,
Where is that chart?
charge 2. The employee remained absent from the premises of 31 Battalion ITBP force at 1800 hours on 14/9/2016 without prior intimation and without permission from competent authority, my lordship. My lord,
Chart
my
number 2.
charge number 2. So
What's chart number 1?
there are two charges, my lordship. One is under charge section 21D and another is section 43, my lordship. So the ITBP Act, my lordship.
Section 43.
Section first is 21D. Section 21D, charge number 1. D, may I read, ma'am? D. Without sufficient cause fails to appear at the time fixed at the parade or place appointed for exercise or duty. So, he failed to attend, that is the parade or place appointed for exercise or duty. And the punishment, my lordship, in the bottom punishment is written, shall on conviction by the force court by liable, be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in this act mentioned. This is very important, my lordship. Punishment is prescribed up to, may extend to 3 years. Now the charge number 2, my lordship. Charge number 2 is section 43, my lordship. Section 43. Violation of good order and any person subject to this act who is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and discipline of the force, shall on conviction by a force court be liable to suffer imprisonment for a term which may extend to 7 years or such less punishment as in this act mentioned. So specifically this punishment has been mentioned. Now I will draw your lordship attention to section 52, my lordship. Yes, ma'am. Discipline. So 2 charges has been leveled against me, my lordship. Discipline. That means I remained absent from the duty at 1800 hours on 14/9/2016. Yes, ma'am.
See, any person subject to this act who is guilty of any act or omission, which though not specified in this act, this must be in this act, isn't it?
Though not specified in this act.
Ill means in, it should be in. There's some typing mistake.
Yes, ma'am. In this act.
Is prejudicial to good
order and discipline.
So it can be anything.
It can be anything. So the punishment has been specified here. So my contention, first contention is that, my lordship, section 52 maybe.
Yes, what is 52?
alternative punishment avoidable by force code.
Okay,
So they punished me under section 52
52.
because they are specific in all the sections, specific punishment has been mentioned. But section 52 says alternative punishment avoidable by force code. Subject to the provisions of this act, a force court may, on convicting a person subject to this act, of any of the offences specified in section 16 to 48. That is, on section 43, punishment is mentioned, and section 21D also punishment is mentioned. So, of the offences specified in section 16 to 48, both inclusive, award either the particular punishment with which the offence is stated in the said section to be punishable, or in lieu thereof any of the punishment lower in scale. That is very important, my lordship. Or any of the punishment lower in the scale set out in section 51 regard being had to the nature and degree of the offence. So under section 51C they have punishment, and section 61C, my lordship, it is a major punishment. This provision, section 52 says alternative punishment avoidable by court, and specifically it says that lower in scale, my lordship. And section 51C, which under which they have punished me, removal from service, it is a major punishment. I have annexed some of the judgments, my lordship, also. In
Dismissal or removal from service.
Yes, it's a major punishment. There are two judgments, my lordship. I have annexed in my affidavit in
We'll come to that. We'll come to all that. Okay.
Yes.
Don't be in a hurry.
Yes.
This is the only case today.
Yes.
Left. Subject to the provisions of this act, the force court may, on conviction of person subject to this also, specified in section 16 to 48.
Yes.
Both inclusive. Award either the particular punishment with which one offence is stated, in lieu of thereof,
Any of them,
any one of the punishment lower in scale set out in section
51. So
lower in scale.
Lower in scale, my lordship.
Anything lower in scale.
So removal from service, my lordship, it is a major punishment. It is not lower in scale.
That I know, Mr. Counsel. There are so many punishment in 51.
Yes, my lordship.
Which one is lower in scale?
My lordship, any fine in respect of civil offence, forfeiture of service.
All these things are there.
Yes, my
They have
lord.
given you removal.
Yes, my lord.
Okay.
And
Okay.
my second point, my lord.
Just a minute. 21D. Also should be 3 years. Then 43 will be for 7 years. 3 years and 7 years. Can be either punished either for 3 years or 7 years, or anything which is lower.
Yes.
In section 51.
Yes.
So this is the provision.
Yes.
Correct?
Yes.
And what is the charge against you?
My charge,
You've been absent.
yes, my lordship. At 1800.
You are absent from exercise.
Yes, my lordship. On that duty. On
What is the date?
Particular day.
What is the date?
My lordship, day is 6/14/2016.
14 and 16.
Yes, my lordship.
Absent from the premises of so and so without prior information and without permission from community authority. The employee remain absent in the time of active duty on camp premises or active duty on camp premises without permission so and so. Then the other one is remain absent on 14/9.
Yes, ma'am.
So these are same thing.
Same thing, two charges, same fact from the so same facts, two charges has been framed, my lord. So,
Main thing is you're absent, that's all.
yes, my lord.
Without
Yes.
permission.
And there I have been found findings, my lordship. Can you kindly see page 33. Page 30. It's the findings, my lordship. Charge 1. Findings. The employee has voluntarily, without any coercion, admitted to the charges brought under charges number 1 and 2. After appreciating the record of evidence and after considering the evidences, the employee is found guilty of the following charges. Found to be guilty, proved guilty. So, my lordship, it is from the order, it is seen that I have pleaded guilty, my lordship. So, there is a provisions, my lordship. section rule, I'll go to the rule, my lordship. 144, my lordship. Four A of rule 144. ITBP.
Rule is of which year?
My lord, same 1994, my lordship.
Which rule? Rule number?
For sub rule 4A of rule 144. 4A.
Please read.
If from the statement of the accused or from the record of evidence or otherwise, it appears to the court that the accused did not understand the effect of his plea of guilt, the court shall after record and enter a plea of not guilty and proceed with the trial accordingly. So, my lordship, if from the statements of the accused, it can be discernible that he could not understand the meaning of guilty, my lordship.
Is that your case?
Yes, my lordship.
That he didn't understand?
My lordship, kindly see the statement, my lordship. His statement.
You were absent on this particular day. You didn't understand that charge?
My lordship, from my statement, my lordship, it is very much clear that my statement is entirely against the plea of guilty.
Where is that statement?
My statement is
Where?
on page 29.
When was the statement taken? During the inquiry?
During the proceeding, my lordship.
Okay.
During the
Read.
After recording of the statements of all the witnesses, regimental number such and such Omkar Pandey F company was examined in presence of an independent witness such and such Abdul Hamid. You may give your statement if you want. You are not bound to give any statement. Your statement may be brought as evidence in writing form. I, regimental number such and such Omkar Pandey F company 10 battalion has been posted in ITBP force since September 2015. During my posting at F company, and I always discharge my duty sincerely. I was engaged for internal security duty, and on 14/9/2016 from 1800 hours, I was given the duty at Nirjuli police station. Sir, due to family problems in my home, I was in a state of disturbance, and as there was no recharge in the mobile, I could not contact my home, and therefore on 14/9/2016 at about 1500 hours, I went to UPA market for recharging my mobile. But I could not get any vehicle at the time of returning, and I came to camp premises by walking, and at around 1830 hours, I reached camp premises, although shift for duty had gone at 1800 hours, and therefore I was absent from duty. Sir, at present I am very much disturbed due to the family problems, and I had not ever remained absent at my duty in the past. And on 14/9/2016, I went to Ipia for recharging my mobile, and due to unavailability of vehicle, I came to camp premises by walking, and therefore I remained absent, and it was my mistake. Sir, kindly allow me an opportunity by considering my circumstances. The mistake happened unintentionally. I shall never do the mistake again. My lordship, from the statement of the accused, my lordship, it is very much discernible that his statement is opposite to the his plea of guilt. When the rule 144A, my lordship, clearly states if from the statement of the accused or from the record of evidence or otherwise if it appears to the court that the accused did not understand the effect of his plea of guilt, the court shall alter the record and enter a plea of not guilty and proceed with the trial accordingly. But
Okay.
I have been
Okay, what happened after your recording of a statement?
they have recorded plea of guilty and they convicted me. They removed from my
Where is the plea of guilt?
my lordship. Impugn order may be seen.
No inquiry done.
No, my lordship. No inquiry has been
After
done. No,
taking your statement,
no, my lordship.
after taking your statement, straight
No
away you are
inquiry has
punished.
been done, and moreover, my lordship, preliminary charge sheet has not been under section 43, my lordship.
Where is your inquiry of plea of guilt recorded?
My lordship.
Is it page 33?
Yes, my lordship.
What is this?
It is all the proceeding in the same paper, my lordship, in the same order. It is
No, what is this? A part of what? Translated copy of the, what is this? Order.
order, my lord.
It is the impugn order.
Indian order. This is in Hindi language. This is a standard.
1 and 2 charge, then after going to the record, so and so, so and so, so and so, to take the charge sheet was then translated and made reduced with the then during trial summary postpone. It is made on the employee admitted his guilt. During trial summary, when the trial number 2 was made, employee admitted his guilt. Findings, the employer voluntarily without any coercion admitted charge in the same. Well, completion of the following charge. Okay, then after that, what happened? What is this down there? Previous punishment.
Yes.
Oh, this is your previous record.
No, my lordship. According to my previous punishment will come when I'll after proceeding, my lordship, I will be if I am found guilty, my lordship. Then for the sentence, my lordship, in my previous record, my lordship, last 1 year there is no negative remarks, my lordship.
Last 1 year, but they have recorded how many?
My lordship.
15 of them.
15, but my lordship, most of the records, my lordship.
You seem to be an habitual absentee.
My lordship. But in the order, it has not been absent.
You are in the habit of being absent.
They have
whether this is to be taken into consideration or not is a different thing.
different.
I know that. But from this, it appears that you are also not very diligent with your work. You are absent now and then.
From my previous record, 15 entries has been there, but in the 15 entries, my lordship, most of the entries, my lord, thereafter it has been regularized. It's not that all the entries, my lordship, I was punished.
Come to the sentence. As provisions as per previous service record. Okay, this is a previous record. May hamper discipline of other employees, having considered the
Last 12 months, patent engagement.
Now, what is the provision under this ITBP rules and act?
Under
Is there a,
rules, fast-
please listen to my query first. You know what I'm going to say? Do you know what I'm going to ask you? If you don't know, then you please listen out first, then you reply. Penalty is imposed to you on the plea of guilt, according to them. Now, what I'm going to ask you is there any provision for appeal or a friend's review like that?
Yes, my lordship.
Have you done that?
Yes, my lordship, I have done it. And
Where is that?
my lordship, annexure.
Regarding appeal, annexure 5.
Yes, annexure.
This is I think this is the order. Where is your appeal?
My lordship, I have filed appeal and it has been rejected.
Where is your appeal? What did you say in your appeal? That I did not understand what you have asked me.
My lordship, annexure 5, page 40, my lord.
Page 5, page 40. Please read.
Regarding appeal prefer against termination from serving by order dated.
No. This is again not what I ask you. This is the order passed by the DIG.
Yes, my lord.
I'm asking you your appeal. Where is your appeal? You have not annexed.
The order of the is the order.
I don't want the order of the appeal. I'm asking you your appeal. These are two different things. First your appeal, then order will come on your appeal. Where is your appeal? Why you do not annex? Why you want to rely upon the other side?
Record has been called for, my lordship.
Record has been called for. That is your appeal. It is not somebody else's appeal. You should make it available to the court, saying that this is what I have said in my appeal. They have not considered what not, etc., etc. Straight away, you are telling me, you're showing me the order. Now we do not know what have you stated in your appeal. Have you taken such ground that you have proceeded against me straight away like that? I did not understand the implication which you have submitted now, saying that I have not understood, but yet they have charged me and proceeded to punish me. Mr. Kato, you have the records with you.
Madam, on the last occasion, madam, the record was called for.
Then, where is it?
Then after they, madam, in.
Taken back?
Yes.
Why?
It's because the no hearing was conducted on
From where did it come, the record?
from, yeah,
From UPA?
yeah.
You produce it tomorrow?
Yes, ma'am.
You're available tomorrow? You're
Well,
coming from outside.
Yes, my lordship.
You're available tomorrow?
I'll stay, my lordship. Because,
Okay, you produce.
Last several occasions, my lordship.
But tomorrow was, what was the tomorrow? I don't know what is the program tomorrow. Supposing the TV gets occupied, you get occupied on the TV the whole day then. Then you must be conversant with the records. You tell me, what did he say in his appeal?
Yes, madam. I will let me manage it.
No, I'm asking you now. You must have read the records.
That was the original.
Two, 3 times it was given, you said.
Madam, original record, they don't want the record.
No, that is not the question I'm asking you. Since the record came to you for some time, 2, 3 times,
Yes, sir.
it has gone back also.
Yes, ma'am.
You did not see what is there in the record, you just give back. If you have gone through the records, you tell me what is written there. Is what Mr. Counsel for the petitioner is saying that I was not made to understand the implication of the charge. Straight away they say that you pleaded guilty and we punish you.
No, madam. As per the record. After madam, the pleaded guilty, madam, all procedure was followed.
What procedure?
Procedure recording of his evidence and other evidence. If not
Again,
pleaded guilty, madam, the all formalities has been followed.
pleaded guilty that we have just read now.
Directly.
After that, one more recording is there. How many recording is there? Statement. See, the statement which was recorded here, it says, oh, this is, of course, this is from the order, impugn order itself.
No, statement, my lordship, earlier it has been taken.
Okay, well, there's one more statement also. Yes, statement at page 29. Statement taken at page 29. Apart from this statement, so you just have a look whether there's appeal is there or not.
Okay, please go ahead. Not found any appeal. Prepared by the.
Appeal order I have.
Okay, let us try to understand the order passed by the DIG. What does it say?
In this regard, it is informed to you that you were posted at internal security duty of the 10th battalion and you were directed to be present at Nirjuli police station for night shift duty. Whereas on 14/9/2016 at 800 hours, you were found absent from the camp premises of the 31st battalion without any prior intimation permission from competent authority, which is a misconduct under section 21D of ITBP Act 19.
Just pause there for a moment. Your duty timing was from what to what?
My lordship, my duty timings is 24-hour duty timings.
No.
My lordship.
It's not
From,
24 hours.
Inline duty. At that time, parade time is 800 hours. From that shift starts. My lordship.
No, you are read somewhere that your duty is still 6:30. It's not 24 hours.
My lordship. Starts from when parade starts. After that parade, they let us.
No, you say that by the time you came back, your duty period was already over. 6:30. You reached back at 6:30.
6:30, 30 minutes.
And your duty time was still 6 o'clock.
Duty starts from 6 o'clock because the first will stand in line. All the personals will appear and then the shift will go.
Roll call.
Yes, my lordship.
Roll call is in the
Yes,
evening.
roll-
There's a roll call.
Roll call. It is called in line.
No, but you have read somewhere that the charge.
Half an hour late because it's roll call starts at 6 o'clock, 1800 hours.
Okay, okay. You have read, I was engaged in internal security duty on 14/9
Yes,
from 1800 hours.
yes, ma'am.
So 1800 hours your duty starts.
Yes, ma'am.
Okay, okay. So you came back, you reached on only on 6:30.
6:30. Half an hour late. I could not attend the.
You had gone to UPA
UPM.
on 1300 hours,
Yes, my lord.
1800 hours.
No, in early in the
No,
day.
sorry, no, you had gone.
Yes, my lord.
What time? 1500 hours. 3 o'clock you went to UPA. You came back by 6:30. Okay. Please continue. Page 40.
14, my lord. In this regard, it is informed to you that you were posted as internal security duty, Itanagar of 10th Battalion, and you were directed to be present at New Delhi Police Station for night shift duty. Whereas on 14/9/2016 at 800 hours, you were found absent from the camp premises of 31st Battalion without any prior intimation, permission from the competent authority, which is a misconduct under Section 21D of the ITBP Act 1992. Your act of indiscipline for which summary force court was constituted has found you guilty as per provisions of 21D and 43 of Indian Tibetan Border Police Force. As per the service record, the disciplinary action has been taken against you for 2 times in the past. 2 times in the past. And furthermore, you have been allowed several opportunities for correction of your behavior conduct, but you could not discharge your duty satisfactorily. Furthermore, you have committed indiscipline by remaining absent from duty from active duty without permission from competent authority, and therefore the decision taken by the commandant 10th Battalion is correct as per rule. Therefore, as per merits of the case, your appeal has been disposed of.
Appeal is under what provision? Under the rules or under the act? Appeal?
Under
What is your ground of challenge?
my lordship. My ground of challenge is, my lordship, that section they have punished me under section 52. And section 52 says any punishment lower in scale.
Okay.
And removal from service is not lower in scale.
These are major penalty.
And moreover,
And that is one ground. Any other ground?
and another ground is that, my lordship, I have not pleaded guilty, my lordship. Even if I have pleaded guilty, my statement, my lordship, they are entirely contradictory to the plea of guilt. So the procedure they have adopted, my lordship, in case of not pleading guilty, it is entirely a different procedure, my lordship. And the third ground, my lordship, which I have taken, is that inquiry under rule, my lordship, under rule 171 has not been done, my lordship.
What is that?
Very much required as per the various judgments of the Supreme Court and the High Court, my lordship,
Rule one,
which I have annexed, my lordship.
171. What is that?
Rule, my lordship, 171 to rule 177. These are rules for causing inquiry, my lordship, for framing of charges, my lordship.
171. Court of inquiry.
Court of inquiry before for 171 to 170. No court of inquiry was done, and moreover, my lordship, there is a they should give first they should frame a charge under the rule, my lordship. That
But there are two charges against you.
that charges, my lordship. First, a charge should be framed, then a proceeding will start, an inquiry will start, my lordship. But nothing has been done under section rule, my lordship.
But charges framed in the order. You see, there are two charges. Charge one, charge two.
And in the impugn order, these charges has been written, my lord. No written charges has been given earlier, my lord.
Is that your pleadings?
Yes, my lord.
Where?
I have three grounds I have taken, my lord.
Paragraph?
My lordship.
Where is
Three
it?
grounds I have taken,
Where is it?
and all my supportive documents are on page 8, my lordship. These are the three grounds which I have taken. The impugn sentence for removal from service was awarded on the basis of accusation which were not formally included in the charges framed against the petitioners. Removal from service from being absent from duty on 14/9 because he is arbitrary, as petitioner's absence from duty was due to some unavoidable circumstances. penalty of removal from service was too much stringent and does not commensurate with the charges of unauthorized absence from duty for one. In support of my third ground, my lordship, I have relied on section 52, which says that any punishment lower in scale may be awarded.
Number 3 is commensurate.
Yes, my lordship.
Number 2 is what?
My lordship, removal service for being absent from duty on is arbitrary in the petitioner absent. This is also, my lordship, it is too much stringent, my lordship.
So 2 and 3 are same.
Yes, my lordship.
You have
Mainly,
only
my primary ground
you
is
have written only 2 grounds and you are submitting 3 grounds.
rules violation, my lordship, that thereafter
Huh?
several rules has been violated. So primarily my ground is that my punishment does not commensurate with the punishment which I have inflicted on me.
But there are judgments against you also. You are not a civilian, you are a uniform force.
Yes,
Discipline has to be there. Without discipline, there is no point
my lord.
being in a disciplined force.
My statement, my lordship, I have stated that I went to India market for unavoidable circumstances. There was no.
You could have tell your any commander there that I'm going to the market because I've got this family problem.
Actually, my lordship,
Please inform the
there was a
authorities.
quarrel. So that
Quarrel with everybody.
no, my lordship.
Then,
When I came, my lord, that are not
if
on
you
record,
have
so I
quarrel
could
with
not
Mr.
submit.
A, Mr. B,
No,
you
my
inform Mr. C.
my lord, these are not on record, so I could not submit, my lordship. Main thing is that my
Main thing is that you are not regular. There are 15 occasions in which they have shown that you are.
Okay, sir.
No. 2 occasions inquiry drawn against you. On 15 occasions or on 13 occasions, they have just gave you some, maybe, I don't know, some quota guard duty or whatever.
One year, there is no bad remarks. Last one.
See, the thing is that if you are an habitual absentee, this is not, you cannot say this is not commensurate.
Last
One, for first time you are absent for half an hour. If you are punished by a removal from service, that is too much. But here is an instance which the record shows that on many occasions you have been absent.
This is very much stringent, my lordship. Because
So-
I have family also, my lordship. My lordship.
Knowing that, you should also be careful.
I'll be
After
careful.
getting the penalty, you cannot start saying that I have got this, I have got that, I have got all these. See, you should know you have very high responsibility in this part of the country.
Yes, my lord. I accept that.
You see, you are
I'll be very much regular.
the
my
entire
lordship, but
citizen depending upon the security that you provide. And if the personnel of this organized force have this kind of people who will go out anytime and come back anytime, there'll be chaos.
any punishment, my lordship, without removal from service, my lordship.
Show me the judgments. What is there?
So, it is annexed, my lordship. With the,
Annexed? Where?
With affidavit in reply, my lordship.
It didn't reply.
Yes. 3 judgments I have relied, my lordship.
On the what? Proportionality.
Proportionality and section 71 to section 177 has not been followed. And third is that minor, if punishment is given under section 52, then a minor punishment may be given. Removal from service is a major punishment. And so rule 45 has not been followed. My lordship. Rule 45 is very much crucial,
What is that?
my lordship. Rule 45.
What is Rule 45? Hearing by the commanding officer.
Yes, my lordship. Here 45.
Hearing by
Hearing by the commanding officer.
when? At what stage?
In a preliminary stage, my lordship, there should be a hearing, my lordship, of the charges, my lordship, before framing of charges. But nothing has been done, my lord. I was not informed about the charges which has been leveled. They have annexed several documents with their affidavit in opposition. They cannot
When were you removed?
my
Date,
lordship,
the date
my lordship. I was removed, my lordship, for order, my lordship,
dated
on 24/1/2017.
2017. Are you sure? Then why did you file writ petition in 2024?
My lordship. Before that, I have filed in my in Jharkhand High Court, and from that, my lordship, I was from Jharkhand, and
Where is that? Show me.
I have annexed to my lordship, and last annexure of the writ petition. That is on page 42. So therefore, some delay has occurred.
What is this order? What does it say?
My lordship, maintainable due to not maintainable the honorable.
When did you file Jharkhand in Jharkhand?
Yes,
2017. Order passed in 2022.
and thereafter immediately I filed against you.
Why say that there's no jurisdiction?
My lordship, is because
You belong to Jharkhand.
yes,
That's why you applied there. You filed there.
yes, I am a citizen. I have domicile in Jharkhand.
You are a resident of,
Yes.
permanent resident of Jharkhand.
Yes.
But according to Jharkhand High Court, the cause of action arose here
Yes,
in AP. That's why.
that's why I filed. Subsequently, I filed this. So delay has been properly explained.
So the Jharkhand High Court also said that this court finds that the petitioner has simply made a bald statement at paragraph number 3 of the writ petition that cause of action arose within the territorial jurisdiction of this court. So without knowing what is what, they just made a statement.
Maybe he is a resident of that state, so fine.
So that of course is there. Cause of action arose.
Cause of action does not arise in there. Not
Now, according to you, the petitioner, paragraph number 3 of your writ petition in Jharkhand High Court. This is what you stated there. The High Court did not accept.
yes. So after that, my lordship, I approved this honorable.
Your removal is in the year 2017.
Yes, ma'am. I filed the case before the honorable Jharkhand High Court in 2017 itself. And after it got dismissed, my lord, I filed this.
Yes, page 34 onwards is your judgment, which you're relying upon. What does it say? Which is the relevant paragraph?
Case the high one is Gopal Das, my lordship. First case, my lordship. This is disciplinary proceeding, section 21 of ITBP Act, Rule 43, Rule 45, Rule 142, and Rule 143 of ITBP Force Rules Summary. These are very important. These has not been followed. So paragraph 2 may be seen, my lordship. On page 8, B79, paragraph 2. It is regarding the petition that the respondent decided to proceed against the petitioner on the allegations of petitioners overstaying the leave for 66 days without sufficient cause and framed the charge sheet under section 21 of ITBP Act. The petitioner has alleged that the respondent did not conduct any inquiry as required under ITBP Force Rules and without affording any opportunity of hearing to the petitioner, dismissed him from service by order dated 12/8/2002. Then paragraph 3. The petitioner filed an appeal under Rule 163 of ITBP.
168.
Yes, 168.
Read.
168 of ITBP Force Rules against the order of dismissal and specified the reasons of his overstaying the leave. The Deputy Inspector General, that is the respondent number 4 by order dated 27/9/2002, rejected the appeal preferred by the petitioner, thereby maintaining the order of the respondent number 5. It is urged by the petitioner that the respondent number 4 neither assigned any cogent reason while dismissing the appeal, nor personally heard the petitioner before deciding the appeal preferred by the petitioner. Then, my lordship, paragraph 5 very important. The petitioner has complained that the respondent, without conducting any inquiry and affording any opportunity of hearing the petitioner as required under ITBP 4 has dismissed him from service. It further adds that the respondent directly framed the charge against the petitioner, my lordship. In my case also, my lordship, they have directly framed. It is further urged that the respondent directly framed the charge against the petitioner, whereas in terms of provisions of ITBP rules 4, ITBP 4, rules number 171 to 177, an inquiry was required to be conducted. It is further contended that no offense report was prepared under Rule 43 of the ITBP 4 rules. In my case also, no offense report was prepared, my lordship. Although wrongly mentioned as Rule 43 of the BSF rules in the petition, the further given to the petitioner that the respondent have not prepared any record of evidence as required under Rule 50 of the ITBP rules. In a nutshell, the stand of the petitioner is that the respondent have not followed the mandate of ITBP rules while proceeding against the petitioner and dismissing him from service. My lordship. Then, my lordship, I'll go to para 13 medicine, my lordship.
What is your rank?
My lordship.
What was your rank? Your rank in the ITBP.
My lordship.
You are a constable, Avildar. What are you?
My lordship, I am constable. GD constable.
Rule number 43, you just read. No offense report was prepared under Rule 43.
Yes, ma'am.
Rule 43 says statement of allegations.
Yes, ma'am. Statement of allegations, they have not given any statement of allegations. It is offensive. Then Rule 13, Rule 43, Rule 45. This para 13 and para 14 are also very much relevant.
So what is the ultimate analysis?
Ultimate analysis, my lordship, the honorable court, when there was sufficient material on record justifying the cause projected by the petitioner for the offense for 66 days to an incumbent on the part of the SFC summary post code in terms of Rule 142 of the ITBP have advised the petitioner to the plea of admission of guilt, which has not been done by the respondent in the instance. In fact, there has been a cosmetic compliance of Rule 142 of the ITBP rule, but not in substance. The Rule 142 of ITBP was penny material to the Rule 1.
Where are you reading from?
Yes, my lordship.
Where are you reading from?
My lordship, it's the para 16 last. Para 16 last. And the appellate portion of the order is para 19. In view of the above, the order dated 12/8/2002 dismissing the petitioner from the service passed by the respondent number 5 is not sustainable in the eye of law, and the respondent number 4(2) on his part has miserably failed to notice the infirmities in the order dated 12/8/2002 passed by the respondent number 5. As noted above by this court. Therefore, the order dated 27/9/2002 passed by the respondent number 4 also does not hold good on the perimeters of law as discussed above. Accordingly, both the orders mentioned above herewith the proceedings conducted against the petitioner are quashed, and the respondents are directed to reinstate the petitioner court with all the consequences benefit except monetary benefits. The respondents are further directed to examine as to whether the petitioner was gainfully employed after the issuance of termination order dated 12/8/2022, and if it is found that petitioner was not gainfully employed from the date of his dismissal from service till passing of this order, the petitioner would be entitled to all monetary benefits. The respondents are further left free to proceed afresh against the petitioner in accordance with law within the period of 3 months from today. So in my case also, no statement of allegation has been provided, no rules have been from rules 143 has not been followed. Rule 171 to Rule 177 has not been also followed.
Okay, this J&K High Court. what is the analysis? Paragraph 15.
Paragraph 15.
Read paragraph 15.
Hearing on charge, it is very important right which is vested in delinquent employee so as to ensure the compliance of principle of OD alteram partem because of the reason that the disciplinary authority has even been empowered to award punishment without remanding the accused for preparation of record of evidence, abstract of evidence or for trial by the SFC. Record further depicts that the commandant heard the charge against the petitioner on 14/6/2002, and in the memo in respect of hearing of charge, it has been mentioned that the charge has been explained to the accused and has been formed part of the proceeding as Annexure I. The court finds the absence of charge as well in the record produced by the respondent, which is stated to have been annexed as Annexure I to the proceeding in respect of hearing on charge. Rather, this court finds the charge dated 15/6/2002 forming part of the old order dated 17/6/2002 issued by the commandant, thereby detailing SHB and Jyotishi to prepare an abstract of evidence in terms of Rule 45 of the rules. The preparation of charge on 15/6/2002, that is 1 day after hearing, which is 14/6/2002, makes the whole proceeding of the hearing on charge meaningless and contrary to rules. In absence of charge, it is difficult to fathom out as to what were the allegations against the petitioner when he was heard by the commandant during the course of hearing on charge. It assumes more significance as in the instant case as already has been prepared by the commandant, then any action taken by the commandant other than the dismissal of charge shall amount to passing of an adverse order against the delinquent employee without affording opportunity of hearing to him. The courts adopted by the respondent number 5 cannot be justified. The court has no hesitation to hold that the proceeding in respect of hearing of the charge conducted by the commandant in absence of charge and offense report are false and in fact non-est in the eyes of law. So, my lordship, in my case also, there is this last line, my lordship. This court has no hesitation to hold that the proceeding in respect of hearing of the charge conducted by the commandant in absence of charge and offense report. My lord, they cannot show the offense. Offense report was not prepared under Rule 143.
This is a judgment passed by the Honorable High Court, coordinate bench. Correct. It may not be binding upon this court.
Yes, ma'am.
Now,
No.
see, you have relied, the court has relied upon one judgment passed by the apex court in Jogeshwar Swine. Union of India versus Jogeshwar Swine.
I have annexed.
This is regarding BSF.
Yes, ma'am.
So the rules in BSF and the ITBP
same,
are
same.
parameteria.
Same. My
They're
lord.
parameteria.
Yes.
Okay.
Second, I have Supreme Court of India, my lordship. One case I have annexed JP Partiwala. It is Union of India and others, but Jogeshwar Swine.
That is what I'm saying just now, Jogeshwar Swine. That has been quoted in this judgment also. So what is the facts and findings in this case?
One, in this case, my lordship, very important is that general plea of guilt and not guilty, my lordship, para 33 medicine, which I have stated, my lordship, that when contradictory statements are there, my lordship, para 33 medicine.
Please read.
My lordship, general plea of guilt or not guilty. The accused person's plea of guilty or not guilty, or if he refuses to plead or does not plead intelligibly, either one or the other, a plea of not guilty shall be recorded on each charge. If the accused person pleads guilty, that plea shall be recorded as a finding of the court. But before it is recorded, the court shall ascertain that the accused understands the nature of the charge to which he has been pleaded guilty and shall inform him of the general effect of that plea. and in particular of the meaning of the charge to which he has pleaded guilty and of the difference in procedure which will be made by the plea of guilt and shall advise him to withdraw that plea if it appears from the record or abstract of evidence, if any, or otherwise that the accused ought to plead not guilty. So from the statement,
Okay,
my lord,
where is this provision out here in the ITBP rules?
my lord, 4A of 144. my lord.
If from the statement of the accused or from the record of evidence or the report, the accused did not understand the effect of his plea, the court shall no, not this one.
4A of Rule 144, which is BSF Rule 140.
142 BSF rule says the accused person's plea of guilt or not guilty, herein so and so shall be recorded on each charge. Where is that in this ITBP rules?
140. 140. Start. 4A is the
Uh-huh. No, you have the ITBP rules.
Yeah.
You read 143 too.
Yes, my lord. If an accused person pleads guilty, that plea shall be recorded as the finding of the court. But before it is recorded, the court shall ascertain that the accused understand the nature of the charge to which he has pleaded guilty, and shall inform him of the general effect of that plea, and in particular of the meaning of the charge to which he has pleaded guilty, and of the difference in procedure which will be made by the plea of guilt, and shall advise him to withdraw that plea if it appears from the record or abstract of evidence, if any, or otherwise that the accused ought to plead not guilty. From the
Same thing, same thing.
same from the statement, my lordship.
So record is necessary. Mr. Kato, please keep that in mind. Now, then after 33, what is the ultimate analysis and finding of the Supreme Court?
In my lordship, para 39, my lordship. In the light of the discussion above and also taking into account that the minutes of proceeding recording of plea of guilt did not bear the signature of the original petitioner, in our considered view, the High Court was justified in finding the dismissal of the original petitioner on the basis of the plea of guilt unwarranted and liable to be set aside in exercise of powers under Article 226 of the Constitution of India. The High Court was also justified in not reopening the proceeding from the stage where the error crept in by noticing that it would serve no useful purpose, as there was hardly any evidence on record and nearly a decade has passed since the date of.
You just read that signature part. Is it mandatory that in the plea of guilt you have to give your signature?
My lordship, the rules does not say, my lordship.
So from where this is very important. In the light of the so the proceedings recording of plea of guilt did not bear the signature of the original petitioner.
Yes, sir. According to Supreme Court judgment, signature is also required.
Where is that your plea? Any signature there?
No, my lordship.
This is a translated copy or what?
My lordship, original copy I have annexed, my lordship. Original copy I have annexed. The repetition. It's a translated copy is there. And
Where is that? Statement of the accused. You have recorded, you have given your signature, RONE, authority, regiment number so and so. What is your name? Abdul Hamid?
no, my lordship. My name is
Omkarnath.
Omkarnath Pandey.
It is here also. Your constable GD.
Yes, my lordship.
You have given your
In
signature.
the impugn order,
In your case, you have given your signature.
my statement, I have given my signature. In the I am on a different point, my lordship. My point is that from the if my statement is considered and my plea of guilt is considered, there is a contradictory between my statement and plea of guilty. If-
How?
Because my statements entirely says that for an unequivocal reason, I went to UPI market and as I did not get the vehicle, I could not return.
That is an explanation.
Yes, ma'am.
That is the explanation.
Exactly.
He does not say that you did not go to UPI. You were there in the camp all along. And whatever charges have been
Charges,
made
my
against me
lordship.
is false.
Charge one.
You
is
say that
without-
you went there,
My lordship.
but because of this problem.
Yes, my lordship. Charge one may be seen
And henceforth,
without sufficient cause.
you will not never do the mistake again.
Yes.
What does it mean? You admitted.
My lordship, charge one without sufficient cause fails to appear. So I have in every charges the condition is without sufficient cause fails to appear at the time fixed at the parade. So in my statement, my lordship,
You will not take permission before going out anywhere. And now you will say that the authority should follow each and every rule meticulously. Huh?
my lordship,
You will go to the
I
market
think,
when your duty is coming up. You'll go to the market.
my lordship,
You will not inform anybody.
my
But once you are removed, you will say that authority should meticulously follow each and every rule, each and every rule and
He
section.
has done mistake, my lordship. He has admitted in his statement, my lordship. But it is not such a mistake that he should be removed from service, my lordship.
Okay. So,
Any punishment lower in scale, my lordship, the authority would have imposed, my lordship.
you had been proceeded against twice earlier. What punishment was given to you?
My lordship, with which I have, they have annexed as my entire service records, my lordship. There is no specific punishment which I can see from there, my lordship. Only some pay cards is there, my lordship. For 1 or 3 days absence, some absence, my lordship. Pay cards. And these pay cards, my lordship, in awarded 15-day forced custody with different. Some of the pay cards also, my lord, later on, my lordship, it has been regularized also. Some of them.
Black cards. What you say? Black cards. Pay cards. What is that pay cards?
My salary, my lord. That is the awarded 15 days post custody with effect from 26/5/6 to 27 9/6/2006. Then 6 days absent period with effect from 28/6/2006 to 3/7/2000 and 3 days absent from period such and such regularized. So, my lordship, if I am absent, my lordship, the authority has seen after considering my representation, they have regularized also. It is not that all the punishment, my lordship, they have inflicted. Some there are unauthorized absence were there, my lordship. Then again, they regularized my unauthorized absence, my lordship.
So, what is that punishment given to you? They say on 2 occasions you have been proceeded, the DIG, appellate authority.
My lordship, in this record, my lordship, there is no punishment, my lordship. No punishment, my lord.
So, you will not tell us what punishment was given to you.
My lordship, previous punishment as per service record is written. It is there in this, my lordship. My lordship, page
Where?
33, page 33.
No, it does not show any punishment.
Yes, my lord. Except that, my lordship, no punishment.
Okay, awarded 15 days post custody. This is like that, like photo card. And 2 days post custody, again this also. Then 7 days post custody, 1, 2, 3.
And thereafter, that forced custody was
Extra
regularized.
duty also. There's so many post custody, 28 post custody also.
And then awarded 7 days extra duty.
You seem to be very fond of moving out here and
But
there.
my lordship,
Hmm.
within last 12 months may be seen. Within last 12 months, bed entry nil. So I have become a good person, my lordship. Last 12 months, nothing, my lordship.
Before 12 months, so many punishments, 15 times.
Before
For the last 12 months, he was very good.
Yes.
Until he went out to the UPI market.
last 12 months,
Correct. But correct. Actual of the malady.
Last 12 months, there is no bad entry. Had there been any bad entry within last 2 months, I have maybe because 12 months specifically they have stated the 12 months, there is no bad entry.
You should have continued, be good for 12, more than 12 months also. After 12 months, you again showed your color again. Mr. Kato, what you want to submit anything today?
Our epidemic nothing.
Okay. Anyway, are you finished? Anything else?
Fine.
Now you have given me 2 judgments.
3
One
judgments
is-
I have given.
3. Where is the third one?
3 judgments and next, my lordship.
Show me the third one. Where is that?
3, my lordship. That is affidavit in opposition, my lordship. Page number 96. my lordship. Where is the affidavit? Page number 96. This is Union of
You have given that continuous pagination, like principal seat. Continuous pagination, writ petition, then the counter affidavit, pagination continues. Out here, that is not followed. It has been repaginated. Understand what I'm saying?
No, my lord.
You have not understood. The writ petition contains pagination.
Yes, my lord.
In the counter affidavit, you continue. Like
yes,
supposing this is 100,
yes, my lord.
in the counter affidavit, 101, 102,
Yes,
something like that.
In the Guwahati High Court also, we
In principal seat, this is done, but not here.
Oh.
So pagination here is different. And you're still referring to all those pagination. That's why I cannot turn.
the page 25 of the affidavit in opposition.
25.
Affidavit in opposition, page 20. This is the judgment Union of India versus Santosh Kumar Tiwari, Annexer C.
Page 25.
And running page 96.
In your reply affidavit.
Yes, ma'am. Affidavit in reply.
Running page.
Running page 96.
There is no running page. That's what I just told you.
25, the page number 25 of the affidavit.
What is the party's name?
Party's name is
Santosh Kumar.
Union of India versus Santosh Kumar. Yes.
This is page 52. Now you turn page 52. You will not be able to turn page 52.
Yes, ma'am.
So you're telling me your page number. I'm giving you my page number. They're not same. Anyway, I've got it. This is Annexer C.
Yes, my lordship.
It is page 52 here. In your copy, what's the page
My
number?
copy is 25 of the affidavit in opposition. Page 25 of the.
That is not my page here. So, which part?
My
Santosh
lordship,
Kumar.
it is Central Reserve Force Act. My same, my lordship, ITBP Act and Central Reserve Police Act. This deals with the
These are actually too minute and not legible also. Should have given a more legible copy. Do you have another citation in
yes, my lordship, I have.
in SCC or something, AR or SCC? What is the equivalent citation?
2023 9 SSC 720. I have stated in paragraph C of the affidavit.
2000?
2023 9 SSC 720 page number. Union of India versus and others versus Jogeshwar Swine. One, this is and this.
Oh, I'm not talking about Jogeshwar Swine. I'm talking about Santosh.
Yes, my lord. 2024 reported, my lordship. 2024 Supreme bracket.
Not Supreme, SCC. Do you have SCC citation
My lord.
equivalent?
There's no SSC citation, my lordship. In a different citation I have got. Paragraph 7 maybe, my lordship of the affidavit.
It is not legible. That's why I'm asking you. You've given me such a copy. It's difficult to see. The print also, font is also very small.
My lordship, I'll give a different copy of them. Paragraph 7, my lordship, I have specifically stated the citation, my lordship, of the affidavit. All the citation I have stated in the specificity on this paragraph 7, 7, 6 and 5, 5, 6, 7. paragraph 5, paragraph 6 and paragraph 7 of the ITBP reply. Judgment favors me, my lordship. That is,
This is regarding section 52.
yes, my lordship. The minor, that is, removal from service is the major one. And they have, as they have punished me under section 52, they could alternative punishment means they can punish me any of the lesser punishment.
They punish you under 52.
Yes, ma'am.
Where is it mentioned?
My lordship, alternative punishment we have given because from section for every section, my lordship.
No, don't explain. Tell me, where is it mentioned?
Yes, ma'am.
52.
52. Section 52.
In the impugn order. Is it mentioned?
No, my lord. Impugn order that is written 51C, my lord. 51C, they have punished me from removal from service. But why they have under section 52 alternative punishment they have given? Because all the offense, my lordship, there is a specific punishment. It has been mentioned in the act, my lord. If section 52 says if a specific punishment is not awarded, then a lesser punishment should be given.
No, that I know. See, 51C. They punished you under 51C.
See, my lord. The two codes of section 52.
That's what I want to know. Where? How do you say the two
Yes,
courts?
my lord, section 52 maybe I read, my lordship. Alternative punishment awardable by force courts. Subject to the provisions of this act, a force court may, on convicting a person subject to this act of any of the offences specified in the section 16 to 48, both inclusive, award either of the particular punishment with which the offence is stated in the said sections to be punishable, or in lieu thereof, any of the punishment lower in scale set out in section 51, regard being had to the nature and degree of the offence.
See, they have not said anything about 52. Correct. They have punished you under 51C.
51C.
So why are you taking me to 52C?
Because they have not punished, the charges are framed, my lordship, under section 48 and section, my lordship, charges were framed under section 21D and section 48. They have not punished me under section, under that particular section. Charge number 2 is section 43 and charge number 1 is section 21D. Section 21D and section 43 specifically, there are punishments stated in the section, my lordship. Yes, because they have not punished me under particular section, my lordship. So it is presumed that they have taken the course of section 52, my lordship.
Okay. Now, what does the Supreme Court say in this regard?
In this regard, my lordship, Supreme Court says, my lordship,
That,
major.
Santosh Kumar Tiwari.
Yes, my lordship. In this, my lordship, that's about the petitioner, my lordship. Rules, my lordship, that in particular summary court, my lordship, they should adhere to all the rules, my lordship. And moreover,
Your printout is supreme today.
para 20,
It's all here and there.
para 20, my lordship.
There are 20.
Yes. The CRPF Act, while dealing with
CRPF also parameteria.
yes, my
CRPF, ITBP, and the BSF.
yes, my
They are quite similar.
quite similar.
Okay.
The CRPF Act, while dealing with offences and punishment, categorizes offence in two parts. One, more heinous offences by section 9 and other less heinous offenses. So by section 10. These two categories of offenses entail a punishment of imprisonment and or fine. The usual disciplinary action which defaults on delinquent employee is envisaged as a minor punishment under section 11 of the CRPF Act, even though many of the punishments specified herein, such as dismissal, reduction in rank, and removal from office of distinction in common service jurisprudence are considered major punishment. That apart, section 11, which describes minor punishment, declares that the minor punishment specified in section 11 may be awarded in lieu of or in addition to suspension of or dismissal. And B, that the power of the commandant or any other authority or officer as may be prescribed to award the specified punishment is subject to any rules made under the CRPF Act. Another important feature is that section 11 does not use common expressions such as dismissal from service or removal from service while describing the punishment. So, Rule 27 by table uses some expressions. From this judgment, my lordship, that is my punishment does not commensurate with the act which I have done, my lordship. Another primary contention, my lordship, it supports this judgment, supports this.
No, commensurate is a different thing altogether. That will have to be considered in a separate perspective. Now, you have imported the provision of section 52.
Yes.
This is again different. It says alternate punishment. Any offense is punishable or specified under 16 to 48. If the punishment is not given,
Yes, under that section,
then any punishment which is lesser under 51 should be given.
So they have not given under lesser punishment. They had given 51 is the major punishment.
This submission and argument
Yes,
has to be considered separately.
Yes.
Okay. And the submission and argument that it is not commensurate or it's not proportionate is a different thing. So these are two things.
Yeah.
Whether absence for half an hour, one should be dismissed from service or removed from service, can be considered to be proportionate is one thing. Another thing is, if you are not punished under the sections under which you have been charged, and which again says that you have to be punished under this provision, but with a lower thing. Not giving you that, whether that would be illegal or would it be arbitrary.
Act supports me, my lordship. Act specifically say, section 52, that any punishment.
But this judgment is it to the point I could still not appreciate. Santosh Kumar Tiwari. It's not clear.
It is regarding, my lordship, CRPF, my lordship. It is regarding punishments, my lordship.
Correct, that I know. CRPF is there. You have read CRPF Act and all that. But how do you apply this to your case? How do you apply? Any other alternative citation? This is from Supreme today.
There are 22 is also very relevant. There are 22. That Santosh Kumar.
How is it related?
Last paragraph, my lordship, paragraph 35. The learned counsel for the respondent made a feeble attempt to challenge the finding done in the inquiry by claiming that inquiry officer and the disciplinary authority did not meticulously consider the respondent defense and the weakness in the evidence laid against them to test the substantiation and to find out whether there is any perversity in the inquiry report. We went through the materials on record and found that there is no such perversity in the inquiry, which in fact it is in fact founded on the evidence on record as noted in the preceding paragraph. Further, no palpable error in conduct of the inquiry was brought to our test. The punishment awarded is also not shockingly disproportionate to proven the misconduct. Rather, considering his past service already a sympathetic role taken in the matter and no further latitude need to be shown to the respondent who was part of the discipline force and has been found guilty of assaulting his colleague. Consequently, we find good reason to interpret the punishment as awarded to the respondent. Further, for the foregoing reason, the appeal is allowed. The imprisonment order of the High Court is set aside. The petition by the respondent shall stand dismissed. The punishment of compulsory awarded to the respondent is affirmed. There is no order dispute. Punishment of compulsory returns suffers from no other infirmity. All the citations are written, my lordship. This judgment, my lordship. These are various citations. Top of the judgment.
That's why I'm asking you. AIR Supreme Court, which year?
AIR SC there is equal 2405. 2024, my lord.
Of which year?
2024.
What is that zero after that? This is not the cite. This is not how the citation of AIR is written.
I have downloaded it from the High Court. What?
No, you should also try to find out the other citation also, because some journals are easier to read. See, Supreme today is not also not bad, but the thing is that the paragraphs are everywhere.
Party High Court bar is I downloaded. All the three judgments from Guwahati High Court Bar Association system. Download.
You are charged with 21B.
Yes, ma'am.
Then the other one is
43.
43.
On the same batch, two charges.
43. And the punishment is imprisonment.
Yes.
3 years and one is 7 months, 7 years. And you're not given either of those.
No.
And such being the case, they should consider section 52.
Yes, ma'am.
Now, if you look at 52, it says that something which is lower punishment should be given. But instead, you are given 51B or 51C.
See, that is my case.
Mr. Kato, that's all.
Yes,
What is your case?
And my case, madam, as per the law point madam, law point madam, courts admittedly madam, madam, measure punishment is not seen in the ITBP Act madam. How the measure punishment can be. Of course, the measure punishment has been madam given by way of dismissal madam. Dismissal lordship has already seen at section 51.
When can you invoke this?
Madam,
When can you invoke this 51?
Yes, madam. That is not prescribed, madam, mentioned, madam. But for minor punishment, lower the rank, madam, lesser the punishment, that is mentioned, madam.
Yes, 52 is there.
Yes, madam. 52 is the only, madam, when that will be invoked when it is in, madam, the like lesser punishment. But when the major punishment is to be given, madam, it is not mentioned there again in the act, madam.
Then how did you punish him with
But
major
that is the
punishment?
one thing, madam, that I wanted to, madam, take the instruction from the, madam, authorities.
No, no. You'll take instructions, I'll give you time for that.
Madam.
But at the face of it, tell me,
Yes, madam.
when charge is given
Yes.
to the petitioner, okay, under 21,
Specifically 21.
specifically under 21D,
Yes, madam.
then again under 43.
Then in that case, madam,
Now, both these sections provide for the penalty.
Well.
One says you should be punished for imprisonment for 3 years or less punishment. 3 years or less.
Well.
Then the other one says 7 years or less.
Well, it's
Now, you're not punished him with imprisonment.
Yes.
Under either of the sections. Instead, you have given him removal from service.
madam, it seems lesser punishment has been.
So then what is your submission regarding section 52?
In
For what purpose is section 52 given then?
section 52 can be, madam, awarded as because, madam, if when there is a lesser punishment. But here, section 21 is specifically section 21D has been invoked, madam. Only remedy is to give him punishment to the extent of, madam, 3 years or less punishment is in this act mentioned.
You can give 7 years or 3 years or less.
Yes, madam.
That much only.
That much only.
Then why did you give removal?
Madam, removal is with instead of giving him the, madam, the imprisonment, madam, he has been removed.
Under what provision? You have not considered section 52. You read section 52, what does it say?
Madam, section 52, as per my understanding, madam, it is completely, madam, alternative punishment available by, madam. But it is specifically mentioned, madam, subject to the provision of this act, a force court may, on convicting a person subject to this act of any of the offence specified in
Section
section 16 to 48, madam.
Okay, so 21D and 43 is
It comes under
included. 16 to 48. Then
Yes, madam. It comes under.
award,
The award either particular punishments with which the offence is stated. Offence, madam, there
that is 3 years or 7 years.
in the said sections to be punishable. Or in lieu of that, any of the punishment lower in the scale set out in section 51, set out, madam, that is also, madam, excluded, madam. In lieu thereof, madam. Without
Huh?
giving in lieu thereof. If it is not given,
If it is not given, if the petitioner was not given either 3 years or 7 years imprisonment,
yes, madam.
in lieu thereof,
Punishment,
give him some other punishment under section 51.
section 51.
But it should be lesser in scale.
Lesser in scale, madam, yes, madam. That has been again, madam, molded, madam.
Lesser in scale, regard being had of the nature and degree of offense.
Any one of the punishment lower in the scale set out in section 51, madam, in general, section 51, regarding regard being had to be nature and the degree of the offense. madam. So meaning thereby, my lord, in the degree of offense, my lord, if it is taken into consideration, my lord, of course, my lord, admittedly, the prescribed is there has to be lesser the, my lord, the scale.
So removal is lesser or more.
Admittedly, my lord, it is major punishment.
So you get instructions on that.
Yes,
When you produce the records,
still record.
in original records.
Yes,
When can you do that?
day after tomorrow, madam.
Day after tomorrow.
Subject to convenience on the part of the other party.
You have completed your argument.
Yes, my lordship.
What can be done?
My lordship. Your lordship allows me to attend the next day through online.
To VC.
Yes.
Sure, can do that.
If
I
the,
just want to get the records and see the records and I want, yes, in that case, what?
Friday, madam.
Why are you spending time like that?
Or Wednesday,
No. On Wednesday.
Wednesday.
by Friday we'll forget everything. Then again we'll have to start from beginning.
Absolutely. Then
Huh?
on Wednesday. But the C is appearing on through RPC.
Okay, please write hard in part. This again on Wednesday. That is 10 September. Mr. M. Katol and ESGI shall produce the relevant records and obtain necessary instructions. As regards imposition of penalty upon the petitioner under section 51 bracket small c. Despite the provisions contained in section 52 of the ITBP Act 1992. Mr. Bond. Vanessa, please get the Google citation from the AIR. So, yes, your AIR was get the language. Google citation either in the AIR or yes. Okay. Vanessa, just going now. That's all.
Yes.
Get it later on. It's no hard. And if you have any judgment on that 51, 52, just take it out.
Through short method study, there's no method the provision is seems method for removal when the initiation is done under the specific section. There is no provisions for the method removal. It has to be initiated if it is to be awarded following the charges. So meaning there were the removal provision is for removal there is no provision in such. It seems.
But yet you remove somebody. If there is no provision, how do you remove somebody?
For removal, the procedure is to be investigated. It seems no provision.
Okay, we'll see. You see.